Wait a minute. नहीं.
We have three judgments in this case. There's one judgment by me speaking for Brother Justice Rishikesh Roy, Justice Pardiwala, Justice Manoj Mishra, Justice Rajesh Bindal, Justice Satish Chandra Sharma, and Justice Augustine Masi. Then there is a second judgment by Sister Justice Nagaratna, which is partially concurring, and there is a dissent by Justice Dulia. So I'll just read out relevant parts of my judgment. The issues that arose for our consideration are: A. Article 31C. Whether Article 31C, as upheld in Keshwanand Bharati, survives in the Constitution after the amendment to the provision by the 42nd Amendment was struck down by this court in Minerva Mills. And B. Article 339B. Whether the interpretation of Article 39B adopted by Justice Krishna Iyer in Ranganath Reddy and followed in Sanjeev Kok must be reconsidered. Whether the phrase material resources of the community in Article 39B can be interpreted to include resources that are owned privately and not by the state. On the first question, we hold, and on this we are all unanimous, there is no divergence of opinion on the first aspect. On the first question, we hold that Article 31C, to the extent that it was upheld in Keshwanand Bharati, remains in force. After tracing the history of Article 31C and the precedents concerning the invalidation of amendments, we observe: by Section 4 of the 42nd Amendment, the words "the principles specified in clauses B or C of Article 39 in Article 31C were replaced with the words "all or any of the principles laid down in Part 4. This is a case of substitution. Section 4 of the 42nd Amendment was subsequently struck down in Minerva Mills. As noted above, where an amendment substituting certain text with certain alternate text is invalidated, the effect is that the unamended text continues in force. This is because the legislative intent of repeal and enactment in such cases is composite and cannot be separated. To give effect to the repeal and not the enactment would result in an outcome which does not correlate with legislative intent, and as Justice Hidayatullah noted in Lakshmibai's case, leave the original section truncated, resulting in absurd outcomes. This would in effect invalidate the original valid and constitutional provision, despite there being no constitutional fault with it, nor the legislature intending to repeal it. Thus, the presumption would be that after Minerva Mills, the unamended Article 31C would continue in force. Indeed, it is evident that such cases as Bhim Singh and Sanjeev Kok proceeded on this presumption. The only plausible exception to this presumption would be if it could be demonstrated that Parliament, when enacting the 42nd Amendment, would have repealed the words "the principles specified in Clause B or Clause C of Article 39, independent of their enactment of the words "all or any of the principles" laid down in Part 4. In this case, no reference to the broader legislative proceedings or external aids is necessary to arrive at the inference that Parliament would not have independently repealed these words. The text of the amendment adopted by Parliament itself makes it abundantly clear that there was no independent intention to repeal. The effect of Section 4 of the 42nd Amendment was to expand the scope of the immunity provided by Article 31C to legislation. Under the unamended Article 31C, immunity was only provided to legislation if it gave effect to the directive principles found in Clause B or Clause C of Article 39. However, by Section 4 of the 42nd Amendment, the scope of this immunity was significantly expanded to immunize legislations that gave effect to any or all of the directive principles in Part 4 of the Constitution. Thus, the intention of Parliament in enacting Section 4 of the Constitutional Amendment was undoubtedly to expand the scope of the immunity granted by Article 31C. This being the situation, it cannot be suggested that Parliament would have repealed the words "the principles specified in Clause B or Clause C of Article 39 if it did not simultaneously enact the broader language expanding the scope of Article 31C. If Parliament had independently repealed these words, it would have not just reduced the scope of Article 31C, but altogether eliminated the effect of the article. Without the words "the principles specified in Clause B or Clause C of Article 39 and Article 31C, the provision would have been rendered nugatory. given Parliament's manifest intention to expand the scope of Article 31C by Section 4 of the 42nd Amendment, it is not plausible to hold that Parliament independently sought to repeal the words, the principle specified in Clause B or Clause C of Article 39 from Article 31C. Therefore, it is evident that the legislative intent of Parliament when adopting Section 4 of the 42nd Amendment was composite, to repeal and enact, that is, to substitute through one single action. This court cannot therefore disaggregate the steps of repeal and enactment and give effect to the repeal even after invalidating the enactment. After Minerva Mills invalidated Section 4 of the 42nd Amendment, the composite legal effect of Section 4 is nullified and the unamended text of Article 31C stands revived. The final question is whether the revival of the unamended text of Article 31C would in some way manifestly contravene the principles laid down in the judgment in Minerva Mills or result in some other adverse consequence. The text of the unamended Article 31C was challenged, and the first part of the article was held by the 13-judge decision in Keshwanand Bharati, while the latter half of the article was invalidated. Therefore, the first half of the unamended Article 31C, which is the subject matter of the present controversy, was undoubtedly constitutional as held by the 13-judge decision in Keshwanand Bharati and further by the Constitution bench in Vaman Rao. Therefore, if as a consequence of the decision in Minerva Mills, the unamended Article 31C continues in force, there can be no question of any unconstitutionality or adverse consequences associated with the unamended Article 31C. Indeed, both the Constitution benches in Minerva Mills and Vaman Rao expressly noted that the first half of Article 31C had been held to be constitutional in Keshwanand Bharati. Given that the unamended Article 31C has been given effect to for over 4 decades, as demonstrated by the decisions of Bhim Singh and Sanjeev Kok, no argument can be raised concerning any legal or practical difficulties with the operation of the unamended Article 31C. Given these findings, we conclude that the unamended Article 31C continues in force. On the second issue, concerning Article 39B, we first look at the question of judicial propriety and discipline and then determine the correctness of the judgments which have been doubted by the reference on their merits. We observe that there is a distinction between holding that private property may form part of the phrase material resources of the community and holding that all private property falls within the net of the phrase. It is here that the judgment by Justice Krishna Iyer in Ranganath Reddy and the consequent observations in Sanjeev Kok fall into error. Justice Krishna Iyer cast the net wide, holding that all resources which meet material needs are covered by the phrase, and any attempts by the government to nationalize these resources would be within the scope of Article 39B. He clarified that not only the means of production, but also the goods so produced fall within the net of the provision. The illustration which he provides on Ranganath Reddy indicates the unworkable nature of such an interpretation. Justice Krishna Iyer observed by way of an illustration that not only do factories which produce cars fall within the net of Article 39B, but even privately owned cars are covered by the provision. Similarly, even in Sanjeev Kok, the net is cast wide, and this court observed that all things capable of producing wealth of the community fall within the ambit of the phrase. In both decisions, it was observed that all resources of the individual are consequentially the resources of the community. An interpretation of Article 39B, which places all private property within the net of the phrase material resources of the community, only satisfies one of the 3 requirements of the phrase. That is, that the goods in question must be a resource. However, it ignores the qualifiers that they must be material and of the community. The use of the words material and community are not meaningless superfluities. We cannot adopt a construction of the provision which renders these terms ocious. The words of the community must be understood as distinct from the individual. If Article 39B was meant to include all resources owned by an individual, it would state that the ownership and control of resources is so distributed as best to subserve the common good. Similarly, if the provision were to exclude privately owned resources, it would state ownership and control of resources of the state instead of its current phrasing. The use of the words of the community rather than of the state indicates a specific intention to include some privately owned resources. In essence, the text of the provision indicates that not all privately owned resources fall within the ambit of the phrase. However, privately owned resources are not excluded as a class, and some private resources may be covered. The resource in question must meet two qualifiers. That is, it must be a material resource, it must be of the community. Thus, the judgments doubted in the reference before us are incorrect to the extent that they hold that all resources of an individual are part of the community, and thus all private property is covered by the phrase material resources of the community. The interpretation amounts to endorsing a particular economic ideology. To declare that Article 39B includes the distribution of all private resources amounts to endorsing a particular economic ideology and structure for our economy. Justice Krishna's judgment in Ranganath Reddy, which was followed inter alia in Sanjeev Kok and Bhim Singh Ji, was influenced by a particular school of economic thought. This is evident from various observations made in these judgments. For instance, in Ranganath Reddy, Justice Krishna had observed that Article 39B constitutes a directive to the state with a deliberate design to dismantle feudal and capitalist citadels of property. In Bhim Singh Ji, Justice Krishna cited Karl Marx in his judgment to observe that taking over large conglomerations of land is necessary to make Article 39 a constitutional reality. Interestingly, in the same decision, the learned judge also expressed his view about the nature of the economy and observed that our economy was in the transitional stage, undergoing a Fabian transformation. Similarly, in Sanjeev Kok, Justice Chinnappa Reddy stated that the words and thought of Article 39B but echo the familiar language and philosophy of socials as expounded by all socialist writers. In a sense, the interpretation of Article 39B adopted in these judgments is rooted in a particular economic ideology and the belief that an economic structure which prioritizes the acquisition of private property by the state is beneficial for the nation. Significantly, both Justice Krishna in Ranganath Reddy and Bhim Singh Ji and Justice Chinnappa Reddy in Sanjeev Kok consistently refer to the vision of the framers as the basis to advance this economic ideology as a guiding principle for the provision. However, as noted earlier in this judgment, the vision of the framers while drafting the Constitution was not to lay down a particular form of social structure or economic policy for future governments. The debates in the Constituent Assembly reflect the foresight of Dr. B.R. Ambedkar. He was categoric in his constitutional vision. The Constitution and the directive principles as he expounded in their fundamental principles rejected the prevalence of one dogma. The Constitution was framed in broad terms to allow succeeding governments to experiment with and adopt a structure for economic governance which would subserve the policies for which it owes accountability to the electorate. According to Dr. Ambedkar, if the Constitution laid down a particular form of economic and social organization, it would amount to taking away the liberty of the people to decide the social organization in which they wish to live. He opined on several occasions that economic democracy is not tied to one economic structure, such as socialism or capitalism, but to the aspiration for a welfare state. Thus, the role of this court is not to lay down economic policy, but to facilitate this intent of the framers to lay the foundation for an economic democracy. Indeed, it is this spirit and its all-encompassing nature of the Constitution which has allowed elected governments since independence to pursue economic reforms and policies based on domestic conditions, international requirements, and political exigencies of the time. At the time of independence in the 1950s and 60s, given the earlier challenges of our republic, the focus of the government was on planning a mixed economy, heavy industries, and import substitution policies. Subsequently, in the late 1960s and 70s, there was a shift towards purportedly socialist reforms and policies. Since the decade of the 1990s or the liberalization years, there has been a shift towards pursuing a policy of market-based reforms. Today, the Indian economy has transitioned from the dominance of public investment to the coexistence of public and private investment. The doctrinal error in the Krishnaiyer approach was postulating a rigid economic theory which advocates for greater state control over private resources as the exclusive basis for constitutional governance. India's economic trajectory indicates that the Constitution and the custodians of the Constitution, the electorate, have routinely rejected one economic dogma as being the exclusive repository of truth. As participants in a vibrant, multi-party economic democracy, the people of India have voted to power governments which have adopted varied economic and social policies based on the country's evolving development strategies and challenges. The foresighted vision of our framers to establish an economic democracy and trust the wisdom of the elected government has been the backbone of the high growth rate of India's economy, making it one of the fastest growing economies in the world. To scuttle this constitutional vision by imposing a single economic theory, which views the acquisition of private property by the state as the ultimate goal, would undermine the very fabric and principles of our constitutional framework. We therefore conclude A. Article 31C, to the extent that it was upheld in Keshwan and Bharti versus Union of India, remains in force. B. The majority judgment in Ranganath Reddy expressly distanced itself from the observations made by Justice Krishna Iyer, speaking on behalf of the minority of judges on the interpretation of Article 39B. Thus, a co-equal bench of this court and Sanjeev Kok erred by relying upon the minority opinion. C. The single sentence observation in Mafatlal to the effect that material resources of the community include privately owned resources is not part of the ratio of decidendi of the judgment. Thus, it is not binding on this court. D. The direct question referred to this bench is whether the phrase material resources of the community used in Article 39B includes privately owned resources. Theoretically, the answer is yes. The phrase may include privately owned resources. However, this court is unable to subscribe to the expansive view adopted in the minority judgment authored by Justice Krishna Iyer in Ranganath Reddy and subsequently relied on this by this court in Sanjeev Kok. Not every resource owned by an individual can be considered a material resource of the community merely because it meets the qualifier of material needs. E. The inquiry about whether the resource in question falls within the ambit of Article 39B must be context-specific and subject to a non-exhaustive list of factors such as the nature of the resource and its characteristics, the impact of the resource on the well-being of the community, the scarcity of the resource, and the consequences of such a resource being concentrated in the hands of private players. The public trust doctrine evolved by this court may also help identify resources which fall within the ambit of the phrase material resource of the community. F. The term distribution has a wide connotation. The various forms of distribution which can be adopted by the state cannot be exhaustively detailed. However, it may include the vesting of the concerned resources in the state or nationalization. In the specific case, the court must determine whether the distribution subserves the common good. The reference is answered in the above terms. The registry is directed to obtain administrative instructions from the Chief Justice for placing the matters before an appropriate bench.
One of the greatest American judges, Justice Benjamin Cardozo, in his book, The Nature of Judicial Process, said, and I quote, The great tides and currents which engulf the rest of men do not turn aside in their course and pass the judges by, unquote. In the field of constitutional law, progressive and dynamic interpretation of the Constitution in light of the socio-economic developments in the country must dominate. To such an organic text as the Constitution of India, a flexible interpretation must be given which the changing times require. Neither can there be canonization of the socialist policy followed by the state, nor can the principles akin to laissez-faire economics be ignored at a time when they have been resurrected by the state itself to suit the developments of the economy in the country and for the benefit of the people of India. Chief Justice Earl Warren's statement is apposite and as a reminder to our judicial conscience. Quote, "Our judges are not monks nor scientists, but participants in the living stream of our national life, steering the law between the dangers of rigidity on the one hand and the formlessness of the other. Our system faces no theoretical dilemma, but a single continuous problem: how to apply the ever-changing conditions, the never-changing principles of freedom. Can principles of liberalization, privatization, and globalization adopted in India since the year 1991, reforms in the economy, and structural changes that have been brought about in these last 3 decades hold a mirror against the socio-economic policies that were followed in the decades immediately after India attained independence? As a result, can the judgments of this court, which interpreted the Constitution to be compatible with the policies of the state, then be considered to be a disservice to the broad and flexible spirit of the Constitution, and the authors of the said judgment being critiqued today? I have perused the erudite and comprehensive opinion authored by Honorable the Chief Justice of India, Dr. Dhananjaya Y. Chandrachur, on the questions referred to this 9-judge bench. I have also perused the opinion proposed by learned brother Justice Dhulia. The letter and spirit of the judgment of the learned Chief Justice has ignited me to pen a separate opinion, concurring with his opinion on certain issues, while giving my own views on certain other aspects, which is also my response to learned brother Justice Dhulia's views. How does ownership and control of material resources privately owned transform into the material resources of the community for distribution as best to subserve the common good? This is the thrust of my opinion. The learned Chief Justice has framed and considered 2 broad issues which have been read. I respectfully concur with the opinion expressed by the learned Chief Justice on the first issue. Before dealing with the second issue, I would like to preface the same with the living tree doctrine of our Constitution. As per Woodrow Wilson, former President of the United States of America, a Constitution must of necessity be a vehicle of life, that its substance is the thought and habit of the nation, and as such it must grow and develop as the life of the nation changes, unquote. In Anwar Ali Sarkar, Justice Vivian Bose in a separate judgment stated that the provisions of the Constitution must not be interpreted without regard to the background out of which they arose. Justice Bose articulated that the Constitution must be interpreted progressively to give life to a great nation and order its being, and not in a manner as would relaunch discarded tools. While being conscious that people who forget their history are condemned to repeat it, he emphasized that a Constitution must be interpreted having regard not only to the historical circumstances under which it emerged, but also in a manner as would mold the future as well as guide the present. Justice Krishnayar adjudicated on the construction of material resources of the community in the backdrop of a constitutional, economic, and social culture that gave privacy to the state over the individual in a broad, sweeping manner. As a matter of fact, the 42nd Amendment had inter alia inserted the word socialist into the preamble to the Constitution. Can we castigate former judges and allege them with disservice only for reaching a particular interpretive outcome? It is a matter of concern as to how the judicial brethren of posterity view the judges of the brethren of the past, possibly by losing sight of the times in which the latter discharged their duties and the socio-economic policies that were pursued by the state and formed part of the constitutional culture during those times. merely because of the paradigm shift in the economic policies of the state and liberalization and privatization, compendiously called the reforms of 1991, which continue to do so till date, cannot result in branding the judges of this court of the yesteryears as doing a disservice to the Constitution. At the outset, I may say that such observations emanating from this court in subsequent times creates a concavity in the manner of voicing opinions on judgments of the past and their authors by holding them doing a disservice to the Constitution of India and thereby implying that they may not have been true to their oath of office as a judge of the Supreme Court of India. Bearing in mind the goals of the Constitution as enumerated in the directive principles of state policy, Parliament and state legislatures have made legislation for giving effect to such goals, and since the inception of our republican state, it is the obligation on the part of this court to consider the correctness of such legislation in light of the vision of the framers of the Constitution, as well as the transformative nature of the Indian Constitution and the intent of the policy makers and the law. It is in the above background that judges of this court have been deciding constitutional cases over the decades. Of course, no particular line of thinking is static, and changes are brought about by the state by bearing in mind the exigencies of the times and global impact, particularly on Indian economy. Such attempts to create an environment suitable to the changing times have to be appreciated by the judiciary, of course, by suitably interpreting the Constitution and the laws. But by there being a paradigm shift in the economy of the country, akin to perestroika in the erstwhile USSR, in my view, neither the judgments of the previous decades nor the judges who decided those cases can be said to have done a disservice to the Constitution. The answer lies in the obligation that this court in particular and the Indian judiciary in general has in meeting the newer challenges of the times by choosing only that part of the past wisdom which is apposite for the present without decrying the past judges. I say so, lest the judges of posterity ought not to follow the same practice. I say that the institution of the Supreme Court of India is greater than individual judges who are only a part of it at different stages of history of this great country. Therefore, I do not concur with the observations of the learned Chief Justice in the proposed judgment referred to above. I say so for the following narration. In paragraph 229, His Lordship, the Chief Justice, has given his conclusions. My opinion relates to conclusions in subparas D, E, and F. And I am also stating a few making a few observations on Raghunatha Reddy, Sanjeev Kok, Abu Kavur Pai, and Basanti Pai. My immediate answer to the aforesaid conclusions is that material resources can, in the first instance, be divided into two basic categories, namely state-owned resources and privately owned resources. There can be no contra opinion to the fact that all state-owned resources, that is, resources which belong to the state, are essentially material resources of the community which are held in public trust by the state. However, with regard to the material resources which belong to the private owners, how do such resources get qualified as material resources of the community? In my view, a privately owned material resource can be transformed and can indeed acquire a status of material resource of the community. What are the material resources owned by a private person which can be material resources of the community? In my view, they would not include what can be termed as personal effects of an individual, such as movables in the form of an individual's apparel, household articles of daily use and need, such as furniture, personal jewelry, kitchenware, and such other articles. These are articles which are of daily need and use. Then I have given what is the meaning of personal effects. This would generally mean such tangible property as is worn or carried about the person, or the designate articles associated with the person as property having more or less intimate relation to a person or possessor of such tangible property as attend. This is what Mr. Rakesh Dwivedi has argued, and I agree. However, I must elaborate on the proposed judgment on the legal distinction between how a private resource qualifies as one of the community and how such a resource is subsequently distributed to subserve the common good. It is on this crucial point that I have penned my separate opinion. Then the five features of Article 39B, His Lordship the Chief Justice has extracted. I have elaborated on that. How do material resources which are privately owned become material resources of the community? The answer to this question lies in the legal devices that are adopted by the state to transform private material resources into material resources of the community. This could be inter alia in the following 5 ways, which are illustrative and not exhaustive in nature. 1. By nationalization. 2. By acquisition. 3. By operation of law, such as vesting of private resources in the state. 4. By purchase of material resources from private persons. And 5. By the owner of the material resource converting as a material resource of the community by donation, gift, creation of an endowment, or a public trust. What is the common denominator in the methods adopted by the state for converting private material resources into material resources of the community? In all these 3 devices at 1, 2, and 3 above, what is of significance is that when by a process of nationalization, acquisition, or vesting of private resources in the state occurs, there are certain legal processes which take place. The first process is to convert the private resource into a resource of the community by vesting in the state, and the second process is to utilize these community resources for the purpose of distribution for the common good. Distribution could be in 2 ways. Firstly, by actual distribution to the deserving and eligible persons as per the policy to be implemented. Second, the state could retain ownership and or control having regard to the nature of the resources and other relevant factors. The third process is that the private owners of these resources are fairly compensated when they lose all rights, title, and possession over such resources when it becomes a material resource of the community. Then I have gone into the details of Ranganatha Reddy, then Bhim Singh Ji in Sanjeev Coke. I'll say a few words on Sanjeev Coke and later Basanti Bai. In Sanjeev Coke, in this case, the Constitution Bench arrived at its conclusions on the validity of the Coking Coal Mines Nationalization Act 1972 and upheld the same. But while doing so, in paragraphs 10 to 14, observations were made with regard to the judgment of this court in Minerva Mills. In fact, paragraph 10 reads as follows, quote, "We have some misgivings about the Minerva Mills decision, despite its rare beauty and persuasive rhetoric," unquote. In my view, those observations were wholly unnecessary, as they lose sight of the outstanding judicial statesmanship exemplified in the majority judgment authored by Justice Y.V. Chandrachur, Chief Justice, in Minerva Mills. One has to bear in mind the fact that the hearings in the case of Minerva Mills as well as in Vaman Rao were proceeding contemporaneously but before different benches, both headed by learned Y.V. Chandrachur, Chief Justice. Realizing the import of the separate opinion of Justice Krishnaiyer in Ranganatha Reddy and the likelihood of the said opinion gaining momentum in Minerva Mills as well as in Vaman Rao, and rightly so, the then learned Chief Justice took upon himself the responsibility of pronouncing the operative portion of the judgment in Minerva Mills in May 1980 and supplementing the reasons in July 1980. And the judgment in Vaman Rao was delivered in November 1980, just prior to the retirement or demitting office of Krishnaiyer J. It is another matter that Justice Bhagwati frowned upon such a strategy adopted in Minerva Mills and in fact penned a common separate judgment in Minerva Mills and Vaman Rao, although the issues were distinct, though overlapping in certain areas, which were minority opinions. In Vaman Rao, only a short order was passed by Justice Bhagwati. Justice A.N. Sen, by his concurring judgment, however, opined that since there was a review of the judgment in Minerva Mills pending before this court, he refrained from dealing with the said decision and from making any observations or comments on the same. This is with regard to the interplay between Minerva Mills and Sanjeev Coke. Basanti Bai. In this case, the court considered the correctness of the judgment of the Bombay High Court by which the High Court had declared subsections 3 and 4 of the MADA as void and had given certain ancillary directions. This court at the outset proceeded to observe in para 13 of the judgment as, quote, we shall proceed to test the validity of the argument, keeping aside for the time being the observation in Sanjeev Coke Manufacturing Company versus Bharat Coke Coal Limited. The question whether an act is intended to secure the objects contained in Article 39B or not does not depend upon the declaration by legislature, but depends on its contents. Reference was made to Ranganatha Reddy, which dealt with the question whether nationalization of bus transport was covered by Article 39B, and to Justice Krishna's observations only in a limited way. It was observed that MADA was protected from challenge owing to the applicability of Article 31C of the Constitution, and it was immune from the challenge under Articles 14, 19, and 31 of the Constitution. It was further observed that land ceiling laws providing for acquisition of land for providing housing accommodation, laws imposing ceiling on urban property, etc., cannot be struck down by invoking Article 21 of the Constitution. Consequently, the judgment of the High Court was set aside to the extent that subsections 3 and 4 of sections 44 MADA had been held unconstitutional and struck down, and the appeal was allowed. What is significant about the judgment in Basanti Bai is, firstly, the case was considered in light of only that portion of the judgment of Justice Krishnaiah which dealt with the aspect of distribution and did not discuss other aspects of Justice Krishnaiah's opinion, which dealt with the judgment, which dealt with the question whether even private property can be equated as material resources of the community. Secondly, in this judgment, it has been expressly stated that to test the validity of MADA, the observations of this court in Sanjeev Court were to be kept aside. Justice Venkatramaya, who is the author of the judgment in Basanti Bai and a member of the 5-judge bench in Sanjeev Court, distanced himself from the observations made by Chinnapareddy J in Sanjeev Court, as well as the other observations of Krishnaiah J in Ranganatha Reddy. However, what is common in all these cases is the fact that nationalization of contract carriages in Ranganatha Reddy, nationalization of coal mines in Sanjeev Court, and reservation of land for public amenities under MADA were all upheld and sustained on the touchstone of Article 39B and protected from attack by virtue of Article 31C. While Justices Krishnaiah and Chinnapareddy supported their reasoning on the touchstone of the word socialist in the preamble of the Constitution, Justice Venkatramaya in Basanti Bai considered the validity of MADA, rehorsed the observations made by Justice Chinnapareddy in Sanjeev Court, and selected only certain portions of separate opinion of Justice Krishnaiah in Ranganatha Reddy. Thus, this court was able to consider the validity of MADA on the strength of Articles 39B, read with Articles 31C, without taking note of many of the observations in Ranganatha Reddy and no observation in Sanjeev Court made by the learned judges on the basis of their socialist philosophy and on socialism. Basanti Bai is a judgment which was delivered in the year 1986 when perestroika was taking place even in a country such as Union of Soviet Socialist Republic, the home to socialism. And there was also a beginning of a new thinking in India too, commencing with 5 technological missions leading to the reforms of 1991, which I have discussed in the earlier part of my opinion. Then I have given my because it's as usual, my judgment is very long. Therefore, for a clearer understanding, I have given a summary of my conclusions and my views to the conclusions of Honorable the Chief Justice. As already said, I am agreeing in the first part and I have elaborated on the second part. Then I say what is significant is that the judgments in Ranganatha Reddy as well as in Sanjeev Court upheld the respective nationalization acts. Therefore, on merits, it cannot be held that Sanjeev Court violated judicial discipline. One cannot lose sight of the fact that in Sanjeev Court, this court did not decide the case only on the basis of the opinion of Justice Krishnaiah in Ranganatha Reddy, but on merits on the validity of the Nationalization Act. Therefore, Sanjeev Court is good law insofar as the merit of the matter is concerned. Then I have said privately owned resources except personal effects as explained above can come within the scope and ambit of the phrase material resources of the community, provided such resources get transformed as resources of the community as discussed above. To reiterate, it would not include personal effects as discussed by me in paragraph 7.6. In my view, the judgments of this court in Ranganatha Reddy, Sanjeev Kok, Abu Kaurbai, and Basanti Bai correctly decided the issues that fell for consideration and do not call for interference on the merits of the matter as explained above. The observations of certain judges in those decisions would not call for any critique in the present times, neither is it justified nor warranted. Reference is answered in the above terms. I must place on record my sincere appreciation to the learned Attorney General, learned Solicitor General and their teams, learned Senior Counsel and learned Counsel appearing for the respective parties, and learned Instructing Counsel for their valuable assistance to this bench. Thank you.
Immensely grateful.
Grateful. I'm going to be short. There are 4 points. As far as Article 31C is concerned, I totally agree with the view of the Chief Justice. And as far as the application of Mafatlal is concerned, I again agree. Mafatlal is in the nature of an arbiter and it's not applicable. The third is regarding judicial discipline, about which a lot has been said. Both not being followed in Ranganath Reddy as well as in Chinnappa Reddy's judgment in Sanjeev Kok. Now, to that, I totally disagree for the reasons which I'll just state in few words. The question now is that when in Sanjeev Kok, the 5-judge Constitution bench unanimously followed the minority judgment in Ranganath Reddy, did it violate judicial discipline of not following the majority, but the minority decision? In my opinion, it did not break any judicial discipline, since in Sanjeev Kok, the 5 judges did not go against the law laid down by the majority judges in the Ranganath Reddy, but only adopted the logic of the 3 judges on which the majority of 4 judges was silent. It is first difficult for me to even come to the conclusion that the 4 judges in Ranganath Reddy entirely disagreed with the minority opinion of Justice Krishna Iyer. It merely says we must not be understood to agree with all that he has said in his judgment in this regard. This is not exactly a disagreement. The majority of the 4 judges chose to remain silent on the subject. It cannot be said that the 4 judges in any way said anything contrary or in opposition to what was laid down by the 3 judges in Ranganath Reddy. Therefore, no judicial discipline was broken by Justice O. Chinnappa Reddy when he authored the unanimous judgment in Sanjeev Kok by adopting the logic of the 3 judges in Ranganath Reddy. The logic, however, is now very clear. In cases where a judge or judges of the Supreme Court in minority has given a decision on a point on which the majority has remained silent, that it would be binding upon the high courts and all the other courts, and for this court at least it will have persuasive value. The 5 learned judges in Sanjeev Kok relied upon the decision of the minority judges in Ranganath Reddy as they were persuaded by the logic and the interpretation given by Justice Krishna Iyer to the phrase material resources of the community. Now, regarding the main question which was there before us, that whether privately owned resources are a part of the material resources of the community, I totally agree with the findings which have been given in Raghunath Reddy and reiterated in Sanjeev Cook. And for this, I'll just there is a expression which is attributed to Justice Louis Brandeis of Supreme Court, although he never said it in any of his opinion. And this is, he said that we may have democracy or we may have wealth concentrated in the hands of a few, but we cannot have both. Now, this expression finds reflection in Article 38 and 39 as well, on which my judgment is based. I'm of the firm view, unrelenting opinion, that the interpretation given by the three judges in Ranganath Reddy and adopted unanimously by the unanimous judgment of Sanjeev Kaur is the correct interpretation of material resources of the community for the reasons. The meaning which must be given to material resources of the community is what has been given to it in Ranganath Reddy by the three judges and what has been followed by the Constitution Bench decision in Sanjeev Kaur. To my mind, this has been the correct interpretation of the phrase material resources of the community. To reiterate what was said by Justice Krishna Iyer and Ranganath Reddy, material resources of the community in the context of reordering of natural economy embraces all the national wealth, not merely natural resources, all the private and public sources of meeting material needs, not merely public possession. Everything of value or use in the material world is material resource, and the individual being a member of the community, his resources are part of those of the community. It is for the legislature to decide how the ownership and control of material resources is to be distributed in order to subserve common good. Once the expansive meaning of material resources of the community is determined, there is no necessity of drawing further guidelines for the legislature to determine as to what will constitute material resources. How to control and distribute a material resource is also the task of the legislature. But while doing so, what has to be seen is that the control and ownership of the material resources be so distributed that it subserves common good of the community. If it does not, then such a legislation can be struck down as the judiciary is not deprived of its powers of judicial review. The legislation is establish a nexus with the principles specified in Article 39B and C to be a valid legislation. This is the law in terms of Keshwanand Bharti and Minerva Mills. To put it differently,
months tenure, and here I have compliments and a complaint, are largely generated by Justice Dhananjay Chandrachur. So it's a compliment and a complaint, and I hope in the 3 days that we have of his tenure, the other judges will also have some opportunity to generate some resources from the side of the bench.
Being very kind. You already saw how many resources have come from Sister Nagaratna and of course Julia.
Because of my
Thank you.
intervention, the matter
Some issues. Maybe I could have said yes.
just read out the important parts of the judgment. We have upheld the constitutional validity of the Uttar Pradesh Board of Madrasa Education Act 2004, except to a small extent, which I'll clarify a little later. First, on the violation of the principle of secularism, a statute can be struck down only for the violation of Part 3 or any other provision of the Constitution or for being without legislative competence. The constitutional validity of a statute cannot be challenged for violation of the basic structure of the Constitution. This court has accepted that a challenge to the constitutional validity of a statute for violation of the basic structure of the Constitution is a technical aspect because the infraction has to be traced to the express provisions of the Constitution. Hence, in a challenge to the validity of a statute for violation of the principle of secularism, it must be shown that the statute violates provisions of the Constitution pertaining to secularism. The High Court erred in holding that a statute is bound to be struck down if it is violative of the basic structure. The Madrasa Act, second, the Madrasa Act regulates the standard of education in madrasas in the state of Uttar Pradesh. The right of minorities to administer educational institutions is not absolute. The state has an interest in maintaining the standards of education in minority educational institutions and may impose regulation as a condition for grant of aid or recognition. The constitutional scheme allows the state to strike a balance between the two objectives of 1, ensuring the standard of excellence of minority educational institutions, and 2, preserving the right of the minority to establish and administer its educational institution. The state can regulate aspects of the standards of education, such as the courses of study, the qualification and appointment of teachers, the health and hygiene of students, and facilities for libraries. Regulations pertaining to standards of education or qualification of teachers do not directly interfere with the administration of recognized madrasas. Such regulations are designed to prevent maladministration of an educational institution. The legislative scheme of the Madrasa Act suggests that it has been enacted to regulate the standard of education in madrasas recognized by the board. The Madrasa Act grants recognition to madrasas to enable students to sit for an examination and obtain a degree, diploma, or certificate conferred by the board. The Madrasa Act allows the board to prescribe curriculum and textbooks, qualifications of teachers, and standards of equipment and buildings geared to ensure the maintenance of standards of education in madrasas. The Madrasa Act does not directly interfere with the day-to-day administration of the recognized madrasas. The provisions of the Madrasa Act are reasonable because they subserve the object of recognition, that is, improving the academic excellence of students in the recognized madrasas and making them capable to sit for examinations conducted by the board. The Madrasa Act secures the interests of the minority community in Uttar Pradesh because 1, it regulates the standard of education imparted by recognized madrasas, and 2, it conducts examinations and confers certificates to students, allowing them the opportunity to pursue higher education. The Madrasa Act is consistent with the positive obligation of the state to ensure that students studying in the recognized madrasas attain a minimum level of competency, which will allow them to effectively participate in society and earn a living. The High Court erred in holding that the education provided under the Madrasa Act is violative of Article 21A because the Right to Education Act, which facilitates the fulfillment of the fundamental right under Article 21A, contains a specific provision by which it does not apply to minority educational institutions. 2. The right of a religious minority to establish and administer madrasas to impart both religious and secular education is protected by Article 30. And 3. The board and the state government have sufficient regulatory powers to prescribe and regulate standards of education for the madrasas. Now, legislative competence. While the madrasas do impart religious instruction, their primary aim is education. Entry 25 of List 3, which pertains to education, must be given a wide meaning to include all ancillary subjects comprehended within the entry. The mere fact that the education which is sought to be regulated includes some religious teachings or instruction does not automatically push the legislation outside the legislative competence of the state. Article 28(3) of the Constitution provides that no person who is attending any educational institution recognized by the state or receiving aid out of state funds shall be compelled to take part in religious instruction or attend religious worship without their consent. The corollary to this provision is that religious instruction may be imparted in an educational institution which is recognized by the state or which receives state aid, but no student can be compelled to participate in religious instruction in such an institution. To read entry 25 of list 3 in the manner proposed by the respondent would render it inapplicable to all legislation which deals with any institution established and administered by minorities which may provide some religious instruction. The Madrasa Act, to the extent to which it seeks to regulate higher education, including the degrees of Fazil and Kamil, is beyond the legislative competence of the state legislature, since it conflicts with Section 22 of the University Grants Commission Act. Entry 25 of List 3, pursuant to which the Madrasa Act has been enacted, has been expressly made subject to Entry 66 of List 1. The UGC Act governs the standards for higher education, and the state legislation cannot seek to regulate higher education in contravention of the provisions of the UGC Act. Next, severability of the provisions. The provisions pertaining to Fazil and Kamil can be severed from the rest of the Madrasa Act. On an examination of the Madrasa Act, it is clear that prescribing the instructional material, conducting examinations, and conferring degrees for Fazil and Kamil were only a part of the functions of the board. The severance of these functions from the board does not impact its entire character. Thus, only the provisions which pertain to Fazil and Kamil are unconstitutional, and the Madrasa Act otherwise remains valid. Conclusions. In view of the above discussion, we conclude that A. The Madrasa Act regulates the standard of education in madrasas recognized by the board for imparting madrasa education. B. The Madrasa Act is consistent with the positive obligation of the state to ensure that students studying in recognized madrasas attain a level of competency which will allow them to effectively participate in society and earn a living. C. Article 21A and the RTE Act have to be read consistently with the right of religious and linguistic minorities to establish and administer educational institutions of their choice. The board, with the approval of the state government, can enact regulations to ensure that religious minority institutions impart secular education of a requisite standard without destroying their minority character. And D. The Madrasa Act is within the legislative competence of the state legislature and traceable to entry 25 of list 3. However, the provisions of the Madrasa Act which seek to regulate higher education degrees such as Fazil and Kamil are unconstitutional as they are in conflict with the UGC Act which has been enacted under entry 66 of list 1. The judgment of the High Court of Judicature at Allahabad dated 22 March 2024 is accordingly set aside.
Grateful minutes.
Grateful, my lord. Grateful, grateful.
My lord, hope this is limited to UP.
Any mentioning today?
Declaration of Fazil and the other degree as unconstitutional. The degrees which have been granted up to today, your lordship would like to say something on that? Because
he followed Yashpal's judgment.
correct.
Because Yashpal says that degrees which pertain to higher education within the meaning of section 22(1), the moment a notification issued by the UGC, then there is no protection to that particular degree. You can't award that degree and it can be awarded only by a university.
So your lordship can only, if possible, add that from the date the notification is issued at least or something. We can leave it for interpretation at a later
Leave
stage.
it at
All right. All right.
But otherwise, we have set aside the judgment of the Allahabad High
Yes.
Court and we have said it's a regulatory act. I think on the aspect of section 22, there was broad acceptance on both sides. In fact, Mr. Salman Khurshid virtually said that yes, that's true.
Correct. Grateful.
Grateful. Grateful, my lord.
Any mentioning?
My lord.
I may make a request, but Lord, there is a petition by Civil Life Foundation, not in relation to the need for trauma care, Lord.
We move this petition, we move the circulation letter, but it's not been listed. May I just pass it over?
It's a fresh case.
Yes, for fresh report.
Let it be listed. Just send an email to the court.
We'll send it done.
When was the email sent?
Give it over. What we want.
Today. And you mentioned it at 12 o'clock.
No, it was sent yesterday.
Yesterday, sent yesterday. Today I'm here.
It will be listed. It will be listed. It will be listed. It will be listed.
Give the details.
Melody, I am also mentioned.
Can I
Melody,
give the details, bro?
Your email will be taken on record and I'll pass an order for listing.
He's lots of emails, I know.
No. I'll don't worry. It's in mind.
My lord, I have also given my request to the learned register, my lord.
For fresh matter.
Yes, my lord.
Okay.
Melody, this is also fresh matter.
It will be listed. Don't worry.
Only minute, Melody, 1 minute.
PIL.
Melody, this is the
PIL.
no, Melody, this is the land acquisition matter. Melody, I am 78 years old. My wife is
Immediately.
Melody, without any notice, any prior, any notice, eviction notice. Today morning they come to demolition, started demolition my house, Melody.
The date of the impugned order.
Melody, impugned order is someone they will.
What is the date? What is the date?
The November, last year November.
If
But
you don't
after
remember,
that,
I told what?
Melody,
It's 28th of November 2023.
Melody, after that,
Your order was passed 1 year back.
Melody,
All right. Second question. When were the defects notified to you?
Melody, the 23 I filed, 25th there.
Defects were notified to you in the vacation.
Yes.
Now you come here suddenly and create some urgency. Can't do it like this. Yes, Ms. Panchira.
My lords, I seek to make a mention. I've already sent an application.
But sir, your matter
It's
will
a
be
fresh
listed.
case.
Your matter will be listed. Your matter will be listed immediately. You'll be listed immediately, but not today. That's all.
My lords, it's
Melody,
Now, because I said something, now don't re-argue.
Melody, I am requesting today itself I will cure the defect.
Oh, but first cure the defects. They notified them in the vacation.
Kindly list tomorrow, my lord.
No. Yes.
that's a fresh matter regarding medical counseling, my lords. The impugned order was passed on 22nd October, filed on 26th.
All right. We'll just yes.
My lords, my kind, today may be the last day for counseling. Therefore, it may be, my lords,
All right.
if my lords can accommodate, kindly see.
Yes, we will see. If not today, tomorrow it will be.
Deeply grateful, my lords, deeply grateful.
There is this contempt petition, my lords, where the Union of India was directed to produce original records pertaining to, my lords, non-grant of permanent permission to the petitioner. My lords, it's a pending contempt, my lords, arising out of my lord's order of 26th of
Let me
February.
see if we can accommodate it now. The time is very short. We'll see this.
My lords, I have emailed as well. Grateful, my lords.
It's got 2-3 fresh matters in today's list. We'll just take 5 minutes on that.
May I please, your lordship? My lordship, this pertains to.
Who's your client, by the way?
My lords, he is an activist and he
Why
has
should
been.
he challenge the conditions of a prospectus for admission of medical students? And he said, I'm a social activist.
My lords, he has been.
Let a student come.
In this field, he has been working for a very long time. Since 2006,
The petition, the
he
petition
is making
by a so-called social activist, purportedly in the public interest, for challenging a condition in the brochure governing medical admissions in the NRI category is clearly not maintainable. The petition is dismissed. Yes.
My lords, on merits, there is some mistake.
Before you argue merits, you must open the door of locus. Who's your client? These are all put up by somebody.
In this field, he has been working since 2006.
It's all right.
He has
We
been
don't.
making representations also.
All right. This has to be tagged with writ petition 548 of 2024. No? Would they close? Same notice and tag. Item 3. Item 3 will be Tola. Same order ends in Tola. और भी है. हाँ, fresh है ना पर वो fresh वाला करो. सही लगता है इसमें.
Plus this. Plus, this is the matter wherein the Honorable High Court in a writ petition filed by respondent number 1 sets aside my letter of acceptance and consequently also the operation agreement which had been executed with the petitioner.
But now the High Court said order a fresh bid.
Please, Millets.
That must already been done now.
Because that's not been done so far, Millets.
September 2024 is the order.
No, Millets, the last communication is at page 279. Would Millets kindly appreciate, Millets, in the entire High Court judgment, Millets, there's not even a single finding against me. Millets, not even a single fault attributed to me. The entire premise, would Millets kindly see 279 Millets. This is the last communication, Millets, 18th of October, where Millets, they say that in terms of the judgment passed by the Honorable High Court, your letter of acceptance stands cancelled and consequently also the operation agreement. Now, Millets, would kindly see the findings of the Honorable High Court, Millets, at page, would Millets kindly see, Millets, page 5 for a moment. In fact, before that, Millets, the state, respondent number 2 files a counter affidavit and categorically states that the document basis which my bid was held to be unresponsive was already there, filed along with the bid at page 771. It was because of their oversight, because they found the hard copy of the document which was already filed with the bid as well as illegible, they could not trace in the first instance. That's the first premise on the basis of which my bid was held to be unresponsive the moment I filed an objection.
Para 15, the High Court says.
Please.
See, para 14 and 15 actually.
Please.
13 also, 13.
Please.
What disturbs us, see that paragraph, what disturbs us is the fact that the qualification of a disqualified bidder
Please.
on 28 June 24 was never informed to the 3 successful bidders.
Please.
Who qualified as per the decision of the Technical Evaluation Committee on 21st May. Only 3 qualified bidders qualified on 21st May, including the writ petitioner as well as the 8th respondent. And the 7th respondent was specifically disqualified. In this context, we specifically extract clause 2.13.2 from the RFP.
That's an incorrect finding because that clause would not even apply. Would Mills kindly have para 5 for a moment at page 4?
Now see para 14, just read out that.
Before that, let's have para 5 for a moment. I would want to show the stand of the state. Page 4, let's para 5. This is the categorical stand of the state whereby they say I did not file any new documents. Would Millets kindly have para 5? The learned senior counsel appearing for Butco, referring to the counter affidavit, would argue that there were no new documents submitted by the 7th respondent. When the 7th respondent was disqualified, an objection was filed, which was directed to be verified by the project director. The project director, on verifying the same, found that the certified payment certificate of experience was available in the uploaded tenure of the 7th respondent.
Now just para 14.
Millets, that's an incorrect finding. In fact, Millets would kindly see the entire clause just preceding para 14, which has been relied upon by the High Court, does not even apply. Millets, the language of the clause is any alteration, modification in the bid or additional information supplied subsequent to the bid due date, unless the same has been expressly sought for by the authority, shall be disregarded. Now, Millets, there has been no new information, no modification or alteration in the bid. Millets would kindly see page 114 for a moment, Millets. When my bid was held to be...
Now, they say that, look, the whole process which was followed was palpably arbitrary. So, High Court has not said award the contract to the other party. They said you invite fresh tenders.
Millets, the premise, Millets, to hold arbitrariness, Millets, there's not even a single finding. Would Millets kindly see what premise?
Para 14.
Yes, Millets, para 14, Millets would kindly see. Millets, I'll read this para. If the documents in the hard copy, which is also supplied by the 7th respondent, was illegible, then only for clarification was sought by the authority could there be information supplied by the disqualified bidder. This finding per se is incorrect. Would Millets kindly see this in the light of page 114? If the premise is wrong because the High Court goes on the premise that if the document was illegible, the authority ought to have sought a clarification. That's not so. Page 115.
You suddenly, sneak into the process.
No, Millets, kindly have page 115. Would Millets kindly have page 114 for a moment? Millets, I'll show how. Page 114 for a moment, Millets.
These are not matters.
No, Millets, but kindly see, Millets, repeatedly held, Millets, the High Court can't sit with a magnifying glass looking in the tender. Kindly see page 114, Millets, I'll not press any further.
You can bid again with
no,
once fresh tender.
Now the problem...
Nobody's disqualified you as such, for the future.
In the entire process, I'm the highest bidder. Now my financial bid is out in the open. Millets, even in this process...
Now we'll have to just rejig your financial bid now in the fresh process. The High Court is rightly said invite a fresh. They've not directed. If they had said give it to the other person, you would have possibly looked at it carefully.
My lords, now the problem is if I participate in a new process, given my financial bid, despite being the highest bidder, being out in the open, my lords, will
Happiness.
my lords, page 114 for a moment, my lords.
Thank you. Item 39. Mr. Shankaran, delay of 359 days in challenging the order.
Well, the reason is this. I was not a party, but in between, I'm not a party in those proceedings. But the consequence of the High Court order is it runs a coach and four through the execution that has been granted to me on 11th July 2024, barely 3 months ago. Just see page 173 for a minute.
Who filed the writ petition?
No, I was not a party to the writ petition, but there were prayers in that writ petition. So just give me a minute, I'll just show you. Page 173, this is July 24.
So you are not a party to the writ petition before the High Court?
No, I'm not a party.
Go to the High Court and say that, look, whatever you have passed affects my rights.
Correct. So I'll tell you the problem. Just see the writ petition's prayer for a minute at page 69.
Page?
Page 69. At page 69.
Annexure?
I'm sorry. That's P2. Annexure P2. Is a PDF page? Do you have a PDF page? PDF is 94 perhaps.
Sir.
I'm just looking at prayer 3 at the top of printed page 69. Yes.
Okay.
If I may read that, to issue an appropriate writ commanding the respondents, particularly so and so, to return the money. These are the builder and the builder's director. To return the money with 8% simple interest to the writ petitioners and other allottees, or by delivering the property by adjusting in the delaying compensation. Now, this is the prayer regarding the refund that has to be granted. Now, I am an individual home buyer. I have a decree in my favor, which from the RERA authority. So I have an execution. That execution is granted. If your lordship
this order
at page 170.
You are not a party to this order.
I'm not, but it is in a representative capacity on a bunch regarding a whole bunch of home buyers.
You will not be affected. If you have a decree, you stand outside.
No, the problem is, my lords, as far as we are concerned, because it's dealing with a whole bunch of projects, as your lordships are
the High Court rejected the submission of the response for constitution of the committee to look into redistribution of the home buyer.
Now, this, if this committee.
But Mr. Shankaran,
yes,
you have a decree in your favor.
Yes.
These general orders of the High Court will not affect the decree inter partes.
No, the problem is this, that I have sought execution. Now, the High Court's order says specifically that there is not going to be any committee, there's not going to be any redistribution of assets.
Right, but
if there's a rejection by the High Court.
So far as your decree is concerned, if you want to execute your decree,
yes,
you have to follow your remedies.
No, but
how will this order come in your way?
No, no.
High Court is not this was a petition under Article 226 filed by someone else.
Correct, by a whole group of home buyers, similarly circumstanced.
They've got partial relief, they've not got other reliefs.
So they had criminal reliefs and civil reliefs. Now, as far as the civil relief is concerned,
no, High Court didn't grant it.
Correct. So the civil relief is this. Now, when I go for execution,
you're unnecessarily, pursuing this because for the reason we'll actually dismiss it on delay, so that it doesn't come in your way of pursuing pursuing your remedies to execute this.
If there isn't a committee, if there isn't some procedure by way of which these refunds can be organized, because that is what is happening in all the other criminal proceedings as well.
You have been put up by those people, the petitioners there.
No, but we are all in the same boat effectively. We need to get our money back.
Then you pursue your remedy in execution.
Even those writ petitioners won't get their money back. Me with an execution won't get our money back.
The High Court's, as brother says, the High Court's refusal to exercise writ jurisdiction can't possibly impede the rights of a party who has a decree.
Will your lordships clarify that?
Please not do anything like that.
Just please clarify that. The problem is, otherwise, there are so many people seeking a bite of the cherry.
Okay, sir.
In Unitec, Amrapali, etc., it was based on individuals' cases that it became larger.
Thank you.
Very well. What did he follow? No. What did he call?
Mr. Matthews Nedumbara, why have you come to the Supreme Court under Article 32? Go to the High Court.
My Lord, in case of the Bombay High Court, move the Bombay High Court for a writ in the nature of prohibition, restraining and prohibiting the NCLT from passing any orders. And my Lord, they refused to tender it, receive it and tender it. Then I
Possession
mentioned
notice
before,
was-
mentioned before the
Possession
court.
notice was issued to you on July 2023. 11
No,
July
no, no, no. The order
2023.
was passed. I'm allowed. Order came to be passed on 29/10/2024 because I was not allowed to move the court. I was allowed to move the court. I wanted to tell the NCLT that the suit was filed in 2021. 2021. And all these proceedings were initiated in 2021.
File a writ petition before the High Court,
It
but
was
more
filed
than
and
the
the
writ
suit.
petition, you file whatever proceedings are available before either the NCLAT or before the
No,
District
NCLT, how can I go? I'm entitled to a adjudication, a finding at the hands of a NCLT, the fact-finding body, and provided it has jurisdiction, in full observance of the principles of natural justice. I'm also entitled to an appeal. It cannot be that I go in and appeal without.
Nedumbara, you have a remedy before the High Court. You filed a writ petition before the High Court. We will not interfere.
No, my grievance is that
So I follow these minutes. May I just take 5 minutes because I thought
Now,
Your Lordship,
since we have, just for the rest of the people in the court, since we have finished the fresh matters, yesterday we had said we'll continue with the rest of the board. We are dealing with the former judges of the High Court, their matter. So we'll take up that. 23, right? Yesterday, this is 4th of November, item 23 that we are taking up. Yes.
that's what I wanted to emphasize. Plus, apologies. Now just circulated. Let's be 5 minutes back. Positions, plus I'll just read it out in 2 minutes time because I thought it was an important matter. And what I failed to place before your lordships yesterday was two parts of the constitutional history of this provision 221. Because your lordships are for the first time interpreting 221, I thought I'll place that also. May I just read out the propositions, please? The principle of financial independence of the judges' judiciary must be viewed both from an institutional perspective and an individual perspective. From the institutional perspective, any measure relating to salaries, working conditions, and post-retirement emoluments, including provident fund and pension, must address the institution as a whole and not just a sum of the parts. In this regard, what must inform the constitutional discourse is the dignity of the constitutional office and not just the person occupying the office. Any measure that creates classes amongst the High Court judges must not only be viewed from an anti-discriminatory principle, but also from the perspective whether the creation of classes affects the dignity and the institutional independence afforded to the judiciary as a whole. That this institutional perspective, my lords, your lordships have penned 2 lines in that Punjab judgment. I will just draw your attention to that 2 lines specifically, that it's not just the individual judges, but the institution as such, about the 2 perspectives. On uniform, 1 minute, sir, let me just finish reading the note. On uniformity, my lords. This is a principle which I failed to articulate properly yesterday. That's why I thought I should put it down.
Punjab judgment is Rahul Garg.
That's right, your lordship judgment is Rahul Raj Garg, Millards.
Where is the what is the part that you want to read out?
I have highlighted the last portion on Rahul Raj Garg, Millards. Page 3. I have extracted it for your lordship's benefit.
Yes.
Any other interpretation would result in a plain discrimination between the judges of the High Court based on the source from which they have been drawn. Such an interpretation would do disservice to the importance of the district judiciary in contributing to the judiciary of the nation and would be contrary to the overall scheme and intendment of Chapter 3 of the statute. It would go against the anti-discriminatory principles stipulated by this court insofar as judges drawn from various sources are concerned. And also, my lords, page 2, your lordship's judgment in All India Judges. That's 2024. That's para 11, page 2 of my note, my lords. The last part on the institutional perspective. On uniformity, my lord, there is something to be said here. May I just read that part and then I'll just show you two.
There are judgments. I think there's a judgment of our court, I think Triloknath Khosa, where we said that once you are born on a Kedar, then the birthmarks are obliterated. So once district judges become High Court judges, and likewise bar members become High Court judges, everybody forms part of one composite institution. And the source from which you are drawn makes no difference. Can you say, for instance, High Court judges drawn from the bar will retire at a particular age, but those from the district will retire at another age?
I'm obliged. I didn't place reliance on those judgments. Also, that one part in Ramakrishna Raju, although it says judges, irrespective of their sources, must have one rank, one pension, must be what must be applied to High Court judges. It places emphasis on 16. Technically not right, because the constitutional post of a judge is not something that is governed by Article 16 specifically, my lords, but the principle remains the same. So it has to be something like.
Here the attorney now.
But it's just the constitutional history on uniformity, because
What is the constitutional history
on uniformity? There's something to be said here. Page 1, my lords, page 2 is the Government of India Act. 221 was the relevant provision at that point of time. The judges of the several high courts shall be entitled to such salaries and allowances, including allowances for expenses and respective equipment in travelling upon appointment, and to such rights and respective leave and pensions as may be from time to time be fixed by His Majesty in Council. So, my lords, what was across the high courts, my lords, for the erstwhile India, my lords, the fixation was done by His Majesty in Council. In the draft that was proposed by Mr. B.N. Rao, the constitutional advisor, they changed the provision and said that it be done by the state legislature. I wanted to show that. The Constituent Assembly specifically rejected that and said there must be uniformity. Would your lordships come to the constitutional advisor's draft? It just starts at page 3, draft article 165, Mr. B.N. Rao's draft article. It says the judges of the several high courts shall be entitled to such salaries and allowances, including allowances for so and so, so and so, as may be from time to time be determined or under act of the provincial legislature. Your lordships gets that, my lords, at page 4. So this was the draft of the constitutional advisor. Over leaf, my lords, if your lordships kindly sees page 5, 197 was the drafting committee's draft. First is the draft of the constitutional advisor, the second is the draft of the drafting committee, which virtually reproduced Mr. B.N. Rao's draft, said that the state legislatures will determine what the high court judges will get. The lordships have that, my lords, draft article 197 at page 5. Then a specific amendment was moved by Mr. Santanam, Anantashayana Mayangar, T.T. Krishnamachari and Srimati Durga Vaideshmukh, page 6, your lordships will find that. When the draft of the drafting committee was voted, they said that in the article 197, for the words the legislature of the state in which the court has its principal seat, the word parliament be substituted and the proviso be deleted. And this was accepted, my lords, at page 177. If your lordship sees, the drafting committee decided to sponsor the amendment at page 9. Page 9 at the foot. Because the page 9, yes.
Last 6 lines. So felt that it would be an anomaly to pay some judges one salary and their colleagues doing the same kind of work a higher salary. On the assumption that there is going to be a general scaling down of all salaries, the committee has decided to retain the provision in the draft that when a High Court judge now in office elects to continue in office under the new constitution, he should be subject to the new scale of pay proposed under the constitution.
So, because there was a definite constitutional intent, my lords, to take it away.
Salary is reduced. Reduced at the birth of the constitution.
So that's what I was saying.
That is, before the constitution got 4,000 rupees salary, that was reduced to 3,500 per month in 1950.
That's why I was indicating to your lordship, there are at least 2 judges who are, we know from autobiographies, Justice Chagla,
yes,
and Justice Rajamanna from the Madras High Court. Both of them who were offered, and both of them specifically took, if your lordship read Setalvat's autobiography, both of them say that one of the reasons, apart from the fact that we don't want to be unsettled from our respective chartered high courts, one of the reasons they say is coming to the Supreme Court means we are taking cut in pay also. So the Setalvat's autobiography specifically records this. What I was trying to point out because we will slip into this mistake if that interpretation is now adopted. The Constitution says that is the other thing. Page 10 is the original provision of the Constitution. It did not say the Parliament will fix by law. Kindly see this, fellows, and compare it with the new text, which is post the 56th Amendment. 54th Amendment, Melos 1986. There shall be paid to the judges of each High Court such salaries as specified in the second schedule. So the Constitution prescribed it till 1986, Melos, till the 54th Amendment. There was no prescription by law by Parliament. Post-retirement benefits, Melos, including pension, Article 2 said Parliament may fix.
Yes.
Pursuant to the amendment, that the Amendment Act also I have placed for your Lordship's benefit at page 11 and 12 of this compilation. It said even the salaries will be fixed by law by Parliament. But definitely, my lords, the entire intent, when you say the Parliament will fix it and not the state legislature, and then you make the post-retirement benefits a charge on the Consolidated Fund of India, and not our means, my lords, that there was a clear intent to have uniformity. Today, the interpretation will mean judges who are drawn from the district judiciary the Lordships will see 221 subclause 1, clause 1 was amended in 1986. Till that time, my lords, it was prescribed according to the schedule. The Lordship just compare page 10 and the present provision.
Oh, so originally the Constitution provided the salaries as in the second schedule.
As in the second schedule.
After the 54th Amendment, it says it shall be fixed by Parliament. Until then, the second schedule will govern.
Until then, second schedule. Even what is more important, my lords, subclause clause 2 of 221, post-retirement benefits were always governed by an act of the Parliament, and it was charged on the Consolidated Fund of India, as I showed to your Lordships yesterday, thereby making it clear that the constitutional intent was not to have different sets of post-retirement benefits for states to fix on their own. So today what we are slipping into is exactly what the constitution makers did want. Because if the interpretation now sought to be canvassed is accepted, saying provident fund, if you are entitled to a provident fund in your respective service in the state, you will continue to get it. Means virtually you can have 25 different models of post-retirement benefits for High Court judges. Clearly, my lords, the constitutional intent was not that. That was the submission on uniformity, my lords.
And you should have 202(3)(d), right?
That's right.
And that's the charge of the salaries and expenditure in respect to the salaries and allowances of judges of any High Court. That's a charge on the Consolidated Fund.
Fund of the state, my lords. Salaries is the charge on the Consolidated Fund of the state, my lords. 112.
112 D3.
That's right.
Post-retirement dues are a charge on the Consolidated Fund of India.
So clearly, charge on the Consolidated Fund of India, Parliament law, and the specific rejection that the High Court's respective state legislature fix salaries, allowances, post-retirement benefits, specifically voted out during the constitutional making
Yes,
process.
Mr. Attorney, what do you have
Just
to say? Now, wait now.
Sorry,
yes.
Sorry, just one more. Because the only provision on Provident Fund, my lords, is Section 20. So there is no separate provision like for salaries. There is a specific provision for a Chief Justice of the High Court. There is a specific salary. For the High Court judges, there is another salary. On Provident Fund, my lords, there is only one provision. So the anomalous situation is this. A member of the district judiciary getting elevated to the High Court can become and retire as a Chief Justice of a High Court. Still will not be entitled to pension under Section 20 if that interpretation is accepted. Whereas his colleagues who have retired as puisne judges, because they are from the bar, will be entitled. Just kindly see 20, my lords. 20 of the Act is the only provision on Provident Fund.
Right.
On salaries, there are different provisions for Chief Justices of the High Court and judges of the High Court, for puisne judges of the High Court. But the anomalous situation today, what will happen? Say, if one of the petitioners here before your Lordships is to, in the near future, become a Chief Justice. He retires as a Chief Justice. The only provision governing his Provident Fund is Section 20. But unfortunately or fortunately, if the interpretation sought to be canvassed by the union is accepted, he was not drawing, they say proviso, he was not drawing Provident Fund in his service as a district judge. Therefore, he will not be. entitled to, even as a Chief Justice of the institution, he will not be. Similarly, I was drawing your lordship's attention to the provision on the Supreme Court Judges Salaries Act also. There also, there is no distinction so far as provident fund between a Chief Justice or a Supreme Court judge or a Supreme Court judge drawn from this class or the other. So that's the only. Grateful.
But just I wanted to answer, my lord, two letters of the government of India itself, my lord. At page number, my lord, 84 and 85.
What terms in the letters? We are looking now the interpreting the constitutional provision.
Very good, lord. The only, my lord, the issue in this, my lord, is threefold, my lord. The first one is that, my lord, that the length of service, because, my lord, see, kindly see, the petitioners, my lord, in 23, my lord, 21.1, 23.1 are the sitting judges of the Patna High Court, my lord. In 23, my lord, there are 7 judges of Patna High Court, my lord, and 23.1 is the 1 judge of Patna High Court, my lord. The issue is threefold. One, that the length of service, my lord, which they have rendered as a district judge, my lord, should be counted as a very clear service as a High Court judge for the purpose of pension, my lord. The second is, my lord, that they are entitled for GPF fund, my lord. And the third one is, my lord.
Mr. Parmeshwar, this issue, this petition, there is only one issue, right?
There's only one issue.
Three issues. Nothing but my prayer, my lord.
Just with the pair in the bottom.
Only issue is in regard to the letter issued by the government of India.
Yeah.
With reference
13th of December 22
letter. That's the only issue.
1 minute. Would your lordship kindly see clause B for a minute?
Addition of the length of service as High Court judge for computation of pension and other personnel.
That's why I say, in fact, item 24 is the example I gave your lordship yesterday. He's a judge of the Allahabad. He's a judge of the Allahabad High Court who retired.
So, but you have argued so far only the issue of provident fund.
So let's finish the provident fund issue, then take up the issue of pension, because the same discrimination. So what has happened to item 24, Milos, is a judge who served for 6 years as a High Court judge in Allahabad from the district judiciary. He was a person who was appointed under the new pension scheme to the district judiciary. He is drawing a pension of 15,005. He is drawing a pension of 15,005 because the interpretation now sought to be placed this, because you have come from the district judiciary, you are not entitled to the pension that bar judges are entitled to. He is also being denied the benefit of provident fund all through the 6 or 7 years of career as a High Court judge of the Allahabad. So this is exactly what the illustration I was giving your lordship yesterday.
But we'll have to, then you'll argue the pension issue separately, or?
Once your lordship say there can't be two classes. There can't be two classes of judges, Melos. I think then the natural corollary is once you serve as a High Court judge, the deal is this. As a sitting judge, you are drawing the same.
Both issues by common judgment, I think.
And the third.
No, that as far as.
And the third one, my lord.
As far as
the third one is, my lord, the transfer of, my lord, the NPS amount of the petitioners, my lord, to the GPF account, my lord.
That's a consequence.
Yes, I'm just informing my lord.
That's a consequence.
That's a consequence.
No.
How do we address the pension issue then?
No, on that I want to tell your lordships, as far as that question is concerned, when the issue came before your lordships, we had the new pension scheme. And a lot of changes have been brought about in the new pension scheme called a unified pension scheme. And they address a wide range of concerns, including civil servants, judges, etc. And that is yet to be notified, but you have placed that on record. So I think it's probably a little premature to go into question saying without considering the features of the unified pension scheme. To get into that question will be a little premature.
I am not getting into whether the new pension scheme must apply to the...
Unless you see the new modified things, how can you get into it? How can you get into
the district judiciary at all?
The district judiciary at all. Question is after you are sworn in as a High Court judge. The question is after you are sworn in as a High Court judge, and when you serve as a High Court judge, you draw the same salary and allowances. But after retirement, somehow the birthmark comes, resurfaces again. So the learned Retiral general will rest assured, Manos, we are not here canvassing the issue whether the district judiciary should have the old pension scheme or new pension scheme.
That's a separate issue.
Right, it'll have certain connection. You can't completely
get the travesty. Can you have a situation where everybody is a member of the same High Court? All are judges of the High Court. One person will get pension under the new pension scheme. The other will be told that you are governed by the old pension scheme.
I don't.
Bar members, old pension scheme.
I don't think we need to labor hard on the question of institutional integrity and all that. I don't think
So
going to
what
say,
we'll do is
I
this.
have some.
For High Court judges, we'll say that once a member of the district judiciary becomes a High Court judge, the conditions of service must be uniform.
I don't think I am on a disagreement on that proposition.
So
As attorney, I don't think.
And we'll clarify.
But I have something else to tell you.
We'll clarify that we are not dealing with the district judiciary in this petition at all.
Yes, I need to only flag your lordship. These writ petitions came to be filed in the context of 3 judges saying that we have a right to have a general provident fund account open. The state objected to it and they sought a clarification from the Union of India in the context of understanding Section 20 as it now stands. The Union of India gave a clarification. And it's only about that all, nothing beyond that. It did not say that district judges recruited from, High Court judges recruited from district judges constitute a different class. So, but the question is, if in Section 20, I have a certain understanding and a certain interpretation. It's only in a very narrow context. Extracted it here in this note.
You have raised the issue of pension for High Court judges in your petition, or
not an issue in this case.
Pension as a district judge. It matters a lot. They have judicial service elevated judge of the High Court.
Now, which is your writ petition?
Third one. The prayers in the writ petition are
162 of 2021.
Which is squarely covered by a lordship's judgment in the Rahul Rajgar regulars.
Right. Now, 4 of 2024 is Mr. Saxena's petition.
Mr. Ajit Singh's petition. 4 of?
And so what we will do is this, Mr. Attorney, we will decide the issue of A, Provident Fund. And second, we will say once they are appointed as judges of the High Court, all judges are entitled to the same pension.
I don't think lordships need to go to the extent to decide this matter, because if lordship has to go to the extent, I need to point out why perhaps there are some issues which need to be considered afresh.
How can there be 2 classes of pension?
I'm not saying there are 2 classes. Please don't take it that I'm saying there are 2 classes at all. I don't say that at all.
So you accept the fact that when a district judge is appointed as a judge of the High Court, his conditions or her conditions must rank at past all others.
This letter has done nothing to alter the text of the law. This letter says on an understanding of Section 20, this is what I understand. That's what it communicates. It doesn't say I'm enacting a new principle, bringing up the discrimination issues. It doesn't say that. So let us only confine ourselves to Section 20. Before I go into that question, I examined it yesterday at a little larger dimension. I got raised with the amicus. Then we have a new pension scheme to which all these district judges they are governed by that. They're governed by a new pension scheme.
So for a moment, we'll postulate that when they are district judges, they are governed by the new pension scheme.
Correct.
We'll for a moment, for the purpose of argument, we'll accept it.
Therefore,
now the question is, what happens when they become High Court judges?
Therefore, if they are now contributing either to a contributory provident fund, if at all, or they are contributing to a pension fund, the question as to what should happen to that fund. Do they now have an entitlement to have a contributory provident fund, switch over from that to a general provident fund? This Act is silent on that question. The Act does not say you will have a right. The Act does not say you will have a right. Nor do we say you don't have a right. They only say on a reading of Section 20, this is how I understand it. So please read Section 20. Does Section 20 bring about a classification? Yes. It says those that are appointed the High Court judges will have a general provident fund account open. But if you belong to a different fund,
contributories to a provident fund, you will be governed by that. No, but you were never contributories to a provident fund.
If you belong to a different class, namely under the proviso, then of course the different dispensation follows.
No, but they were never, the proviso doesn't apply at all.
No, the proviso will apply to them.
How? Let's see the proviso.
So therefore, today there is a slight change. What I want to bring to your Lordship's notice is, in view of the new pension scheme, before I take Section 20, I want to present an issue.
Pension scheme does not apply to High Court judges at all.
No.
The new pension scheme does not apply to High Court
judges. But the district judges
are governed by the new pensions.
Right, but
Insofar as
but
they
can
are
we
governed,
say that once he is appointed as a High Court judge, he'll still be governed by the
before
old
we reach that
pension
stage,
scheme?
before we reach that stage,
Yeah.
insofar as they are governed by that, they are contributing to a new pension fund. So that fund is a different fund altogether. Is in here the fact they're contributing to a pension fund. So section 20 will have to be read either accordingly. He talks about, the proviso talks about a contributory provident fund. If he talks about a contributory provident fund, a proviso, those who are governed by a contributory provident fund will continue to be governed by that even after appointment of the High Court. That's what section 20 says. Unless you read section 20.
But provided they were contributing to a provident fund.
Correct.
They were not contributing to a provident fund at all.
And therefore, today, the question is, in view of the new pension scheme, there is a scheme which has been substituted. So how do we address that question? Therefore, the letter only says, the letter therefore says,
all that we have to say
applied
is
my mind.
that all that we have to say is this: once they are members of one institution, they are governed. They must be governed by the same provident.
Kindly look at prayer E. The prayer E in the writ petition is transfer the funds which is part of the pension fund, transfer it to the general provident fund account.
It's consequence.
Yes, we can't do that.
I have answered, Lord.
We cannot do that at all. Therefore, this question needs to be addressed by the government at a different level. It's not merely, therefore, when the question
has been pending for this long. If the government had addressed it, we would have allowed, we would have.
The Lord said to interfere to even get salaries.
No, look at the difficulties.
We had a situation where a judge in Patna High Court was not being paid his salary.
No, that they didn't want to have his salary because they want to have a provident fund account open. It is not that he did not pay that. Let us not attribute.
Why would a judge not want his salary?
I applied my mind to this
situation where, judges are treated as second-class citizens, that the judge of the Patna High Court was not paid a salary.
No. We have
not paid a salary until we intervened.
No. Let me try to clarify this position. That we have now. The question is, if a new scheme has come into position, it's entirely different, right? Contributory provident fund, as it originally stood, means there are contributions by the employee, contributions by the employer, interest, bonus, etc. A general provident fund does not contemplate a contribution by the employer or the authority. It's only my contribution as an employee. Now, therefore, today, as a district judge, I did not have a general contributory provident fund. I'm only contributing a contributory provident fund, not a general provident fund.
Question, Mr. Attorney.
Yes.
You said that the transfer of NPS contribution into GPF account is not permissible.
It's not permissible.
Okay. For the time being, let us proceed on that foot.
Yes.
What will you do with this NPS?
Exactly. That question is certainly, I was trying to understand that question.
Okay. Is it your argument that if it is not permissible to transfer it to general provident fund, is it permissible to transfer it to the contributory pension scheme?
No, it already belongs to the
Fine.
pension fund.
So it remains
It
as.
will remain, either it will remain there or
But-
it can be given
So
back.
it can be given back to the
can be given
concerned
back.
officer.
Yes, yes.
But your argument is that in any event, after his elevation as a High Court judge, he cannot open a GPF account. That
Because
because
the Act
there is no
itself,
contribution.
the Act itself provides for it. The Act says, let's close our eyes to the pension fund scheme, as if there is a contributory provident fund scheme in position. Section 20 contemplates two different classes. A judge who is appointed the High Court judge will have a general provident fund.
You see, Section 20 doesn't apply.
Kindly see, in the context of Section 20, it has happened. Their assertion was in the context of Section 20.
Okay, what is the problem if the NPS contribution is given to them on their elevation? GPF account can always be opened. The only problem is your argument is that they have not contributed anything. So that would lead to some financial implications. Are the financial implications coming that way?
Therefore, the question is,
The whole thing boils down to only one thing: financial implications.
not only finance.
But
I think
to avoid, to overcome the financial applications, should we draw two sets of judges?
Let us try to look at it differently. I understand. I'm thankful to Ross for this. But the question is, if under Section 20, as I read it, if two distinct classes are contemplated, because of the pension scheme,
For the purpose of provident fund.
Correct.
For all other purposes.
If I am a contributory provident fund class, I continue to belong to that class, even after appointment to the High Court.
There is no contribution.
That's what Section 20 says.
There is no concept of a contributory fund.
There is no provident fund.
There is no concept of a contributory provident fund. Let the Attorney General show one piece of paper, Milods, where
Today
judges.
not.
You are repeatedly saying contributory provident fund. There is no concept of a
High Court judges, right?
Yes, there is a concept of contributory provident fund.
Yes, yes. 1 minute.
There is.
Show it.
No, there is a the section talks about a
Show
contributory provident fund.
Show us that there is a contributory provident fund for district judges.
There is not.
There's nothing like that.
I will show that. I'll try to show that. What I'm trying to say,
There is
what
no
I'm trying to
contributory
say,
provident fund for district judges at all.
I'm only trying to read Section 20. Section 20 contemplates a contributory provident fund.
No,
It contemplates.
No. It contemplates a provident.
The proviso contemplates. Kindly see the proviso. Kindly see the proviso.
It speaks of provident fund.
No. Kindly see the proviso. Let us
Judge
forget
will
that.
But see
Read Section 20.
The main part, every judge.
Kindly read Section 20.
Yes, every judge shall be entitled to subscribe to the general provident fund.
Provided.
But proviso will have to be read in context with the main provision.
Provided the proviso, the proviso says,
disjunctive of the main.
No, the proviso, what does the proviso say? Why is the proviso there at all? The proviso contemplates a class of judges who will be appointed as High Court judges who contribute to a provident fund, which so and so before appointment as a judge.
In terms of the proviso.
There was today this provision has undergone a change. That's what I'm trying to point out.
This provision has not undergone a change. Section 20 remains as it is.
Undergone a change because judges are contributing to the pension fund.
Mr. Attorney, one line, and perhaps you will be able to enlighten us.
Yes.
Just see the proviso. This is exactly what has fallen from my Lord the Chief Justice.
Continue to subscribe to the Provident Fund.
To which he was subscribing before his appointment as a judge.
Correct.
The words are, to which he was subscribing before his appointment as a judge. Proviso only clarifies that he shall continue to subscribe. But you have to first convince us.
The problem is arisen today.
Every judge shall be entitled to subscribe to the General Provident Fund. No,
I entirely agree.
Show us. Show us.
I'm not saying no to that.
Show
but
us.
The problem today is something else. The problem today is something else.
Mr. Attorney, just one second.
Show us that they had subscribed to the General Provident Fund.
I can't alter the text of the provision. I'm not
not
doing that.
It doesn't apply.
I'm not doing that. Please appreciate this difficulty. The difficulty is in prayer here they say, shift all our pension contributions in the pension fund to the General Provident Fund account. That is a prayer. The section does not contemplate it.
That we may or may not grant.
Give it back to them. give it
We
back.
can give it back to them.
Okay, give it back to them, but you can't deny that, sorry, we will not allow you to open a GPF.
No, they can open a JPF account today and start contributing.
Mr.
No problem with
Parmeshwar,
that.
the issue
But
of
our problem with
transfer-
that.
Just one second.
Yes.
The issue of the transfer of the contributions from the pension fund, from the general provident to the general provident fund, is a slightly different issue. What we can direct is, once they become judges of the High Court, a general provident fund must be opened in their name, right? And post their appointment as High Court judges, they must have a GPF. All right. Before their appointment, there was no provident fund at all. Therefore, once they were appointed as judges of the High Court, a provident fund must be opened, and all contributions must be made like any other bar judge thereafter.
I have two.
No difficulty at all.
Perhaps what is in your mind is whatever has been accumulated in NPS, if it goes there, it will yield something more. That's precisely
That will amount to altering the text of the pension fund.
what we can do is, Mr. Parmeshwar, NPS amount, we'll ask them to give you back, and we'll direct them to permit them to open a GPF and start afresh.
Very well. In fact, we not the higher letters, we not government letter P7 and P8 says so.
I know difficulty.
P7 and
I
P8
only
says
wanted
so.
to.
Now we'll dictate this. Chalo, ye le lo.
Give me only 5 minutes.
Wait a second.
I'll make some.
You know, you don't understand.
This very matter.
We have to at least finish what we can right now. Please, we will not be able to finish anything.
And lastly, Mr. Lordship, may only observe that the retirement benefit, entire retirement benefit of the judges, my lord, who are appointed for judiciary, my lord, so we are at par with the High Court judges appointed for the bar. The entire retirement benefit, my lord.
Just wait for the judgment to be
Very
declared.
good. I'm sure.
So this will govern writ petition number 3 writ petitions Act 232 of 23, 3 of 2024, and 1262 of 2021.
No, 1262 is Mr. Dwivedi's matter.
That will keep separate.
That's right. So these two are the only ones concerning Provident Fund, your lord. First,
yes. Invoking the jurisdiction of this court under Article 32 of the Constitution has been invoked by how many judges totally?
8 sitting judges. 8 sitting judges of the Patna High Court.
Both the matters together.
Yes, my lord. 7 judges, my lord, in 232, and 1 judge in petition number 3, my lord.
All right. By 8 judges of the High Court of Patna who are aggrieved by a communication dated 13 December 2022 issued by the Under Secretary to the Government of India in the Department of Justice of the Union Ministry of Law and Justice to the Senior Accounts Officer in the office issued by this so and so. The communication has been issued to the Senior Accounts Officer in the Office of the Principal Accountant General, bracket A and E, at Patna. Full stop. The petitioners in writ petition 232 has 7 petitioners. No?
Yes, yes.
The 7 petitioners who are the 7 petitioners in writ petition civil 232 of 2023 were appointed as district judges on 15 April 2010, while the sole petitioner in writ petition 3 of 2024 was appointed on 15. All of them were appointed, sorry. They were all the petitioners were appointed as district judges on 15 April 2010. Full stop. The 7 petitioners in the first of the 2 petitions were appointed as judges of the Patna High Court on 4 June 2022, while the sole petitioner in the second petition was appointed as a judge of that High Court on 22 November 2023. Full stop. Appointment as judges of the High Court, their salaries and conditions of service were to be governed by the High Court judges, bracket, Salaries and Conditions of Service, bracket, Act 1954. Full stop. Chapter 3 of the Act governs salaries and pensions. Full stop. Section 13A envisages that the Chief Justice of the High Court, of a High Court, would be paid by way of salary an amount of rupees 2,50,000 per mention, and that a judge of a High Court would be paid by way of salary an amount of rupees 2,25,000 rupees per mention. Full stop. Section 14 provides for the payment of pension in accordance with the scale and provisions set out in Part 1 of the first schedule. वो वहां पर footnote देके 14 कॉपी कर लीजिए. Section 15 provides for makes a special provision for the payment of pension for judges of the High Court who have held any other pensionable post under the Union or State in accordance with the scale and provisions in Part 3 of the first schedule. However, every such judge is entitled to elect to receive the pension payable either under Part 1 or Part 3 of the schedule. Let's stop. Section 20 governs the payment of Provident Fund and is in the following terms. ये नोट में पेज 20 को पेज 17 को मिल जाएगा आपको AA. नोट 1 रोमन 1 में पहले बोलता हूँ. नोट रोमन 1. Full stop. After the petitioners were appointed as judges of the High Court, no steps were taken by the authorities to open a general provident fund account as a consequence of which, on their retirement, they have not received any terminal benefit pertaining to the provident fund. Correct? Full stop. The scope of the controversy in the present case turns on the interpretation of the provisions of Section 20. However, before we proceed to interpret the statutory provision, it would be necessary to advert to the governing constitutional provisions. Good stuff. We have heard so and so per likh. Article 216 of the Constitution provides for the Constitution, provides that every High Court shall consist of a Chief Justice and such other judges as the President may from time to time deem it necessary to appoint. Article 217, bracket 2, provides for the sources of recruitment of judges of the High Court, dash, from the bar, or as the case may be, judicial service, dash, and specifies the qualifications for appointment from the two sources. Full stop. Article 221. Next. Article 221 in its present form is in the following terms. Bracket Act 1986. Full stop. Prior to its substitution, Clause 1 stipulated that there shall be paid to the judges of each High Court such salaries as are specified in the second schedule. Full stop. By the substitution of Clause 1, the salaries which are payable to judges of the High Court are determined by Parliament by law, and until such determination is made, were to be governed by the salaries specified in the second schedule. Clause 2 of Article 21 provides that every judge shall be entitled to allowances and to such rights in respect of leave of absence and pension as may be determined by a law made by Parliament from time to time. The proviso to Clause 2, however, contains a guarantee that neither the allowances nor the rights of a judge in respect of leave of absence or pension would be varied to their disadvantage after appointment. Article 202, bracket 3, bracket D. Article 202, bracket 3 provides for expenditures which will be charged on the consolidated fund of each state. And subclause D stipulates that expenditure in respect of the salaries and allowances of judges of a High Court would fall in that category. However, as regards the pensionary payments which are paid to judges of a High Court, Article 112, bracket 3, bracket D, bracket small Roman 3 stipulates that the pensions payable to or in respect of judges of any High Court which exercises jurisdiction in relation to any area included inter alia in the territory of India would be charged to the Consolidated Fund of India. Full stop. The constitutional scheme is thus unique, for High Court judges is thus unique in that the salaries and allowances payable to judges of the High Court which are determined by a law enacted by Parliament are charged to the consolidated fund of each state under Article 202, bracket 3, bracket D. However, the pensionary payments payable to the judges of the High Court in pursuance of a law enacted by Parliament under Article 221, bracket 2 are charged to the Consolidated Fund of India by virtue of Article 112, bracket D, bracket 3. Full stop. Elaborate provisions have thus been made by the Constitution to secure both the independence, of the Indian judiciary by providing them a measure of financial independence, both during their term of office as judges and after retirement. At this stage, it would be material to note that Section 221 of the Government of India Act 1935 contained the following provisions in regard to the payment of salaries and allowances for judges of the High Court. ये आपको रोमन 2 वाले नोट में पेज 2 पे बी मिल जाएगी. When the Constitution was being drafted, the Constitutional Advisor, the draft framed by the Constitutional Advisor, Sir B.N. Rao, RAU, contained a stipulation in draft Article 165, by virtue of which the salaries and allowances of judges of the High Courts, including of judges of the High Court, and matters pertaining to leave and pension would be determined by or under an act of the provincial legislature. Article 165 was in the following terms. ये page 4 को CC. In the draft constitution, draft article 197 also contemplated that the salaries and allowances and matters of leave and pension would be governed by a law enacted by the legislature of the state. यहाँ footnote देके ये page 5 को D copy कर लो. During the course of the debates that's the Constituent Assembly, right?
That's the minutes of the drafting committee.
During the course of the deliberations in the drafting committee, the the words, into invert commas, the legislature of the state in which the court has its principal seat, into invert commas complete, was substituted by the words, was substituted by, into invert commas, parliament. As a consequence of this, comma, the constitution did not leave it to the wisdom of the legislature of each state to determine the salaries and allowances payable to judges of the High Court, or for that matter, issues pertaining to their rights in respect of leave of absence and pension. The Constitution history is of significance because it indicates the careful manner in which the provisions pertaining to salaries, allowances, and pensions of the judges of the High Court were drafted so as to preserve the independence of the judiciary. It is in this backdrop that it becomes necessary to consider the position of a judge of the district judiciary who is appointed as a judge of the High Court. Is such a judge, upon appointment as a it is not in dispute that members of the bar who are appointed to the High Court are entitled to subscribe to the General Provident Fund in terms of Section 20 of the Act of 1954. The issue is as to whether such a benefit would not be available, is whether such a benefit can be deprived to a judge of the High Court who is a member of the district judiciary before their appointment as a judge of the High Court. We'll just take a little break for lunch and come back at that. वो थोड़ा सा last दो sentence type करके मुझे दो साबर. We'll come back and we'll just complete that. Mr. K. Parmeshwar, the mic is query. We're not calling upon has broadly addressed the court on 3 propositions. Poland. First, it will be noted that the provisions of the Constitution and of the statute governing the conditions of service of sitting and retired judges, of sitting and former judges, must be construed from the perspective of providing financial independence, both at the institutional and individual level. Semicolon, next line. Second, it has been urged that high courts are constituted. Second, it has been urged that there must be uniformity in the service conditions of high court judges, both during service and after retirement. And the intent underlying Article 221 would be defeated by making a distinction between the conditions of service available to judges of the High Court, to brackets, and former judges, into bracket, based on their source of recruitment. Third, it has been urged that all judges of the High Court constitute one single class as defined in Articles 216 and Article 221, irrespective of the source of appointment. And in consequence, the principle of non-discrimination in regard to conditions of service must apply. Stop. Mr. Dwivedi, should I record your submissions here, or will Mr. Rakesh Dwivedi, then senior counsel, who has appeared in a companion matter, has also addressed the court in the present batch of cases, urging that bracket 1, the provisions of the Constitution do not contemplate 2 classes of judges, semicolon, bracket 2, all high as a constitutional institution, as constitutional institutions, as holders of constitutional offices within constitutional judges, within constitutional institutions, there is only one class of High Court judges, irrespective of whether they have been drawn from the bar or the district judiciary. D, the requirement of financial independence, which is a fundamental constitutional postulate underlying the provisions of Articles 202, bracket 3, bracket D, Article 112, bracket 3, bracket D, bracket 3, and Articles 216, 217, and 221 apply in equal measure both to service and bar judges appointed to the High Court. Semicolon. And 4, the law under Article 221, bracket 1 must of necessity be uniform for all judges of the High Court, and no subclassification be permissible. the domain of the law, which is contemplated in Article 221, is for the determination of the quantum of salaries. There cannot be any bifurcation between the entitlements of judges of the High Court drawn from the district judiciary and the bar. Let's stop. Mr. R. Venkatramani, the Learned Attorney General of India, the Learned Attorney General for India, on the other hand, has placed reliance on the proviso to Section 20 of the Act of 2024, of the Act of 1954, and urged that the true intent of the provision is that a judge who has held a pensionable civil post under the state, into brackets, in this case the district judiciary, bracket, will continue to subscribe to the Provident Fund to which he was subscribing before being appointed as a judge of the High Court. Full stop. With the implementation of the National Pension Scheme in 2004,
from 2004.
With effect from 1 April 2004, all district judges appointed after that date came to be governed by the NPS, with a consequence that any subscription to the Provident Fund must be in a manner consistent with the new scheme. Full stop. Hence, it has been urged by the Attorney General that even if a member of the district judiciary is appointed as a judge of the High Court, they would not be entitled to the benefit of the General Provident Fund, which is otherwise applicable to judges of the High Court. Full stop. Finally, it has been urged that in any event, there is no justification for the petitioners to seek a transfer of the amounts of the NPS contribution as district judges to the GPF accounts if they may be directed to be opened by this court. Next. The fundamental postulate of High Courts are constitutional institutions their status as constitutional institutions is recognized by Article 216. Full stop. Article 216 does not make any distinction between the source to which judges of the High Court are recruited. Full stop. It stipulates that a High Court shall consist of a Chief Justice and such other judges as the President may from time to time deem it necessary to appoint. Full stop. In other words, once appointed to the High Court, every judge ranks at par the institution of the High Court comprises in totality of the Chief Justice and all other judges appointed to the court. Once appointed, no distinction can be made between judges for the purpose of the payment of salary and for extending other service conditions, both during and after they cease to be in service. Full stop. Article 217, which provides for the appointment and conditions of the office of a judge of the High Court. On the other hand, specifies the source from which the judges are drawn, namely the district judiciary on the one hand and the bar on the other. Stop. The sources from which the judges of the High Court are appointed, however, has no bearing on the fact or bearing on the position that once appointed to the High Court, all judges constitute a homogeneous class without any distinction. Full stop. Making a distinction between the judges of the High Court based on whether they were drawn from the bar or, as the case may be, the district judiciary, and to place judges drawn from either of the sources at a comparative disadvantage would fundamentally militate against the sense of homogeneity which is created by the constitutional provisions. Full stop. Apart from the principle underlying the creation of a homogeneous class of judges appointed to the High Courts, the Constitution has made specific provisions which guarantee the financial independence of judges. So financial independence for judges is a necessary ingredient of maintaining judicial independence. Full stop. The Constitution made a departure from the provisions in the Government of India Act 1935, in terms of which the salaries and allowances, as well as pension payable to judges of the High Court, were to be determined by an act of the provincial legislature. Though initially a similar provision was contained in the draft articles of the Constitution, the conscious departure was made in the Constitution as it was framed. Full stop. Before the 54th Amendment, the Constitution provided that the salaries of judges would be such as are specified in the second schedule. After the constitutional amendment, which was brought into force on 1 April 1986, the salaries of judges of the High Court are determined by Parliament by law. Likewise, matters pertaining to allowances, leave of absence, and pension are governed by parliamentary enactment. The object of providing for a parliamentary determination of service conditions, in particular, the salary, allowances, and pension, was intended to bring about a national uniformity in the conditions of service, both of sitting and former judges. Full stop. Clearly, therefore, it is not within the contemplation of the Constitution that the payment of salaries and the extension of other benefits, both during and after service, should be left to the vagaries of determination by individual states and the schemes which are applicable to the civil service officers discharging duties under each state. Full stop. The payment of salaries to sitting judges is borne from the consolidated fund of every state in terms of Article 202, bracket 3, bracket D, salaries and allowances, 3, bracket D, full stop. The importance which is attached to the payment of pensions is clear from the fact that pension repayments are charged on the consolidated fund of India. Full stop. These provisions of the Constitution have been curated with care, based on the overarching need to preserve judicial independence. Next, the principle of non-discrimination, which animates Article 14 of the Constitution, applies a fortiori in regard to the manner in which sitting and former judges of the High Court are to be treated, irrespective of the source from which they are drawn. So, this principle of non-discrimination was underlined in the decision of this court in P. Ramakrishnan Raju versus Union of India, 2012, 2014, 12 SEC 1, page 1. Where the court held note number 1 में para 22 में page 7. Okay. This will be CC, na? DD, page 7 and 8. This was reiterated recently in the decision of this court in Union of India versus Justice Retired Raj Rahul Garg, 2024, INSC 219, where the court held EE para 23 in note 1. Above all, the locus classicus on the subject is the decision in All India Judges Association versus Union of India, 2024, and SC 226, where the interrelationship between judicial independence and financial independence has been reiterated in the following terms. Copy down at para 14 FF. This leaves the court with the task of interpreting the provisions of Section 20 of the Act of 1954. The substantive part of Section 20 stipulates that every judge shall be entitled to subscribe to the General Provident Fund into brackets services. Full stop. The expression every, coupled with the expression shall, underlines the mandatory character of the provision, which does not brook any exception. However, what the proviso does is to deal with the case of a person, is to deal with the case of a judge who has held any other pensionable civil post under the union or a state. In terms of the proviso, such a judge shall continue to subscribe to the Provident Fund to which the judge was subscribing before appointment as a judge. It's properly construed, the proviso was not intended to be restrictive in nature. It is well settled that provisos can either be treated as an exception or in the nature of an explanation to the main provision. The proviso in the present case is more in the nature of an explanation so as to allow a judge who holds a pensionable post under the union or a state and who is subscribing to a provident fund to continue to do so even after appointment as a judge of the High Court, so as to ensure that the benefits which have already accrued would not be disrupted. Though the Learned Attorney General placed reliance on the proviso to contend, don't say though, the Learned Attorney General placed reliance on the proviso to contend that judges of the district judiciary who are appointed after 1 April 2004 are governed by the new pension scheme. At this stage, it would be necessary to clarify that in the course of these proceedings, we are not adjudicating in any manner on the issue of the applicability of the new, or on any issue pertaining to the applicability or the validity of the new pension scheme. It is necessary to issue this clarification since that issue is pending before this court in independent proceedings. The simple issue before the court is as to whether a member of the district judiciary, upon appointment as a judge of the High Court, would be entitled to the benefit of the General Provident Fund, which is available to all High Court judges under Section 20. Unlike the payment of pensions, where, as already noticed, there are different provisions in sections 14 and section 15. Inter alia, sections 14 and 15 of chapter 3 of the Act of 1954. There is only one specific provision in regard to the payment of Provident Fund, which is contained in section 20. The proviso to section 20, even if it is to be treated as an exception, would have to be strictly construed, and so construed would have no application to the facts of the present situation. It is not in dispute that members of the district judiciary appointed after 1/4/2004 did not subscribe to any provident fund, in which event there was no question of applying the proviso to deprive them of the benefit of the General Provident Fund, which is available under the substantive part of Section 20. Next, for the above reasons, we have come to the conclusion that bracket 1, the High Courts are constitutional institutions, and upon appointment as judges of the High Court, all judges partake of the character of the holders of constitutional offices. Semicolon. Bracket 2. Article 221 of the Constitution. Article 221, bracket 2, neither Article 200, bracket 2, neither Article 221, bracket 1 of the Constitution, which empowers Parliament to determine the salaries of the judges of each High Court, nor Article 221, bracket 2, which empowers Parliament to determine the allowances and rights in respect of the leave of absence and pension, contemplates that a discrimination can be made between judges of the High Court based on the source from which they are drawn. 3. Article 217 of the Constitution specifies distinct sources of recruitment for judges of the High Court from the district judiciary, or as the case may be the bar. But once appointed to the High Court, all judges form one homogeneous class of constitutional office holders. 5. The importance which has been ascribed by the Constitution to judicial independence stems from the rationale that there is an intrinsic relationship between financial independence and judicial independence. 6. The provisions pertaining to the guarantee of service conditions while in service and post-retiral benefits for judges is amplified by placing the salaries and allowances of sitting judges and the pensions of retired judges as a charge, respectively, on the Consolidated Fund of the State and the Consolidated Fund of India. 7. Any determination of the service benefits of sitting judges of the High Court and the pensions which are payable to them and the retirement benefits which are payable to them, including pension, must take place on the basis of the fundamental principle of non-discrimination between judges who constitute one homogeneous group. 8. All judges of the High Court, irrespective of the source from which they are drawn, perform the same are entrusted with the same constitutional function of discharging duties of adjudication under the law. Full stop. Once appointed as judges of the High Court, their birthmarks stand obliterated, and any attempt to make a distinction between judges, either for the purpose of determining their conditions of service while in service or any form of retiral dues, would be unconstitutional. Full stop. The letter which was addressed by the communication which was addressed by the Deputy Accountant General, by the Minister, by the Undersecretary to the Government of India and the Department of Justice, purportedly stated that as the judges appointed by direct recruitment to the state judicial service after adoption of the NPS by the state governments and subsequently appointed as High Court judges are covered by the contributory pension scheme of the state government, they would not be eligible to subscribe to the General Provident Fund. The letter is clearly based on a misappreciation not only of the statutory scheme underlying Section 20 of the Act of 1954, but is fundamentally at odds with the constitutional status of all judges of the High Court, irrespective of the source from which they are drawn. Full stop. The letter dated 30 December 2022 shall accordingly stand quashed and set aside. Full stop. In consequence, we allow the petition by directing that a General Provident Fund account shall be opened with effect from the date of the appointment of every one of the petitioners, into which contributions shall be credited at par with all other judges of the High Court, irrespective of the source from which they were drawn. Full stop. We are not at this stage issuing a direction, though it was sought in the petition, for the transfer of the contributions lying in the new pen under the NPS to the General Provident Fund, since the entire issue in regard to the applicability and since the entire issue in relation to the NPS is pending before this court for independent determination, independently, independent of these proceedings.
Should be returned, my lord. It should be returned to the judges.
Shall, however, be returned to the petitioners with the
Contribution, whatever is lying in the NPS account.
What the amounts which are due lying to the credit of the to the petitioners of the account holder petitioners shall, however, be returned to them within a period of 4 weeks from the date of this judgment.
That is their contribution, the pension fund.
Whatever is lying in the account.
No, it is
whatever
the whole amount, what they have
the entire amount.
Whatever they have contributed.
Whatever is lying in the account.
No.
To put in something.
Yes, that's what I'm saying. It is their contribution, it will go to them.
Because then I'm saying your lordship, then what is?
No,
because
that's the problem.
So that at least address the court. Sir.
Yes.
I'm saying the Attorney General first argued that it can't be shifted to the GBF account. Now, what will happen is if you withdraw the government's contribution, whatever interest it has accumulated on that will completely diminish.
We are not saying that the government's contribution will be.
He's asked, the Attorney General is saying only
no.
Judges' contribution should go back. If the government's contribution to the NPS is withdrawn, then what happens is the judges from the district judiciary for 30 years, for 15, 20 years, whatever it is.
They have accumulated a huge.
You will never get it.
No.
So whatever
they have accumulated 30.
So whatever is what we originally dictated is correct. The account must be returned.
The account must go back. Not just the contribution. Whatever is the balance in
the account.
There's nothing like a balance in the account. Today there are two contributions.
But it's an account, right? It's a balance means
they have contributed.
The bottom line.
No. I have a problem there. Whatever they have contributed.
Or government's contribution.
No,
it's a fungible. It's a fungible contribution.
Can't be again split up and
you can't have a pension money given to them as a contribute as a provident fund today. Whatever they have contributed, go back to them.
No, we are not saying give it to their provident fund account.
No, whichever account.
We are saying return it to them. That's all.
You lost kindly. See, there are two elements of contribution.
How can you retain that money? It's lying to their credit.
If it will be given to them if they are going to be a pensionable aspect. If they are not going to get a pension from that, it is government's money. Why should it go back to the pension now?
It's not government's money.
It is. So they have to do. Therefore, under this act, either they go back to and part 1 or part 3 of the case maybe. Therefore, we are not entering in that question today. So how the entire corpus will be given to them?
But how can you retain the corpus?
It is only in the event of retirement it will be given to them. So there is a problem. That's why I say this can't be done. We are not paying pension to them today.
But insofar as the district judges appointed to the High Court are concerned, they will be now entitled to pension as High Court judges.
Therefore, it will be a different pension scheme altogether. So they can't get a pension out of this.
No, 1 second.
Yes.
For once they are appointed to the High Court, they are entitled to a pension at par with all other High Court judges.
Quite right.
Right?
That does not mean that the contribution in the pension fund they have done so far, government contribution, will be given to them as pension today. It can't go as a pension.
But then tell us one thing.
Their contribution they entailed take back.
But when they get pension as High Court judges, will that take into account the years of services?
This question will have to be addressed independently. You can't hand over the entire corpus to them.
This puts our judges on the district judiciary.
And then they will get it after 12 years, 10 years of service in the High Court. Therefore, today we can't hand over the entire corpus to them. It's a serious question. That's why I address this issue before the lordships.
All right, this we'll have Mr. permission on this and Mr.
Puts the entire judges from the district judiciary at a clear disadvantage when they take oath as a High Court judges. Because what they have done, suppose they enter the service at 34, 35, they have been contributing to the new pension scheme. The government is contributed together, both monies together are invested in a fund to the account, their account. As Mr. Dwivedi said, it is fungible. It is one account now in their hand. It is one account in their hand. On one hand, you are saying for the service as district judiciary, they are not entitled to provident fund. If the prior E were to be accepted, the entire amount had to be credited to the provident fund, because what will then happen is High Court judges at the time of retirement who are elevated from the bar will get about 30-35 lakhs in provident fund because they have been contributing for 10 years, 12 years. A district judge who's already only been contributing for the last 6 years in a provident fund account.
You'll only get what is accumulated.
What will get accumulated in the provident fund of a High Court judge who's elevated from the...
So they'll not get their NPS contribution and they'll get only 5 or 6 years, because most of them, Mr. Saxena, how long were you a judge of the High Court? 5 years. So somebody like Justice Sudhir Saxena will get what? 5 years contribution per year. And if you don't give them the NPS accumulation, then that will be very serious. That will be a matter very serious.
It needs to be addressed.
Seriously,
Therefore,
sorry to say.
How do we dovetail the pension contribution on the understanding it will be a pension payment?
But surely that is to their account. You have to give them that contribution. They are not going to demand anything else.
No, it is their account provided. It goes into pension. I think
what can't be done to a legislation today by simply amending a pension scheme. What was to be protected by an article of Act of the Parliament, what was sought to be protected by the Constitution today, the underlying basis now step by step is taken away by the executive by changing the scheme.
We are addressing a different argument altogether.
No, 1 minute.
We are not.
No. I'm saying yes. So far as the effect is this. So I'm saying for the district judiciary, I'm not arguing that at the moment. But the learned Attorney General can at least say, so far as High Court judges are concerned, they will not be put at a detriment today. Surely our district judges are going to be put, who are going to be elevated to the High Court.
Firstly, I'm not able to understand.
Get, like Mr. Srivastava, Justice Srivastava, who's one of his clients.
Yes or no?
He will only get what he was joint registrar in the High Court adjudicated Allahabad. He was a district judge. So he will not get anything at all. He will only get his provident fund.
Justice Vikas Srivastava called me a month back and he showed me his bank account, my lord. He is getting a pension of 11,253. That's the plight of High Court judge.
No, that's the next issue.
Not being given to him.
Anyway,
Not
get
because
resolved
of this.
by saying that there can't be any discrimination in regard to pension.
That's right. That's
taken
care by law.
There are two other fundamental flaws in the submission of the learned Attorney General. The first is that he says, I'll return the contribution made by the judge, but retain the government contribution. So one can appreciate the argument that you will not pay anything and you will retain the whole amount because it's a single account. How do you split it up? On what basis? Where is the legal provision for saying that you return
the credit which was approved to him?
Yes.
There's no flaw.
If there is to be a return, and the second flaw is that now the contributory provident fund is coming to an end. It's terminated. Now he becomes a judge of the High Court, and the general provident fund is to apply to him.
So whatever has remained,
So whatever is
has to be handed over to him. At least at the time of retirement. We are not saying at the time of appointment.
Exactly.
But he has retired.
No. We're not talking about retired. We are talking about how the scheme will work now.
No, judges are continuing.
The scheme, how will the scheme work now? Therefore, to say that the entire pension fund should be now treated as a general contributory provident fund, I think there is a misconception there. You can't do that.
There are there's one more flaw in this argument. There's one more.
Because under the
there's one more flaw in this
what
argument.
will see
वही बोल रहा हूँ.
Bolan, the entire amount at their option. Just at their option.
Because under the Act, if you want to choose either Part 3 or Part 1, you will have an election.
PF
You will elect.
PF has nothing to do.
PF has nothing to do
That's
with
it.
nothing to do with
That's
that.
all. If the PF has nothing to do with that, but we are somehow getting into the pension issue. That's what I'm trying to point.
There are two flaws
So
in the
if there
argument.
is anything
straight away.
the Lordship says,
One, the union doesn't collect the pension fund. So it is not for the union to say whether the state must return it or not.
So
The union doesn't collect any of this money. The entire district judiciary, the pension, salaries, etc., are borne completely by the states. The union has no business. The union has no business collecting the money. It doesn't collect the money so far as pension is concerned. So I don't understand why they have to oppose this. Number one. Number two, my lords, there are three components of what is lying in their account today in the new pension scheme. One is their contribution. One is the state government's contribution. Three is what has accumulated in the market. How do you differentiate that from the judges' contribution?
This was the same question. How do you get it as part of the provident fund?
One minute. The union has no say so far as the pension of the district judiciary is concerned. And I have serious reservations for the union to continuously oppose this. It is for the state to say. In fact,
what, invested in a mutual fund or what is that?
Market-based mutual fund. So there is no question. So whatever is there.
So when they have to be paid, they have to be encashed and paid.
In fact, for two of the judges in Patna, after they were sworn as judges of the High Court, the entire corpus from the NPF's fund should shift it to the GPF account. But it was kept in suspended animation because of this letter. Would your Lordship kindly see page 57 of writ petition number?
So it was kept. It was transferred to the GPF.
It was transferred to the GPF, kept in a suspended animation. So it is not as if the states have not done it. The states have understood it rightly, but for the intervention of the Ministry of Law and Justice saying that they are not entitled to GPF at all. So I am saying whatever is accumulated to the account.
You said that they should be returned to them at their option.
That's right.
But would you not just make it clear? The sections 14 and 15, and we have some serious questions there.
14, we have said we are not dealing with pension at all.
Not dealing with that.
Yes.
But if the moment we give a different color to a pension fund, and if we now brought into a corpus of a provident fund, with all the accumulations,
we are not brought it into the corpus of the provident fund at all.
With all
we have just said that look, paid over to them. That's all.
That's number one. But then if they get the entire corpus available in the pension fund, which means they're getting a pension today. They're getting a pension amount from the pension fund today. It is not being put into the provident fund account.
They will be entitled to a pension as High Court judges after they retire. But that pension will be based on the number of years service which they render.
No difficulty about that at all. I'm not getting into that question at all. Nobody is getting into that.
How can we deny them what was credited to their pension account before their
account? Pension they will earn at the time of retirement, it has to be in terms of the scheme of the Act, and either Part 3 or Part 1 they will elect. So, but before that, today what you're saying is, whatever is now available in the pension fund, which they have contributed so far, will be handed over to them today.
Otherwise, transfer it to their GPF account.
That's what. How do we do that? Therefore, there's a problem there. We try to point
out. There's a problem. There's a problem. Then you pass on.
It is not. It is a contribution by the government. It's an entire different set of features. How do you bring a fund which has different features into the?
Transfer it to their GPF account, or you give it to them. Tell us what you want to do. That's why you were saying that they were saying transfer it to our GPF account. You said no, we can't transfer it to the GPF account. Then pay
of course, because there's a conceptual difference. GPF account is what you pay. You can't have an entire.
But you can't hold on to that money. Because
it is
now, because
it will be their money.
This will never be part of their pensionary payments as High Court judges. Those are completely independent. If they are completely independent, the pensionary payments as High Court judges, then you can't retain this money today.
It amounts to this.
I can understand if you say that, look, if we say that this corpus is what is going to be part of their pensionary payment when they retire as High Court judges, then you can say you can't get it today. But if what they get as High Court judges who are retired is independent of this particular corpus, then that has to be given to them. It is their money.
It amounts today. It looks like this, that we are giving them an option of electing to Part 3 or Part 1, as the case may be, as if this fund is available to them as pension. Please look at it, it is available to them as pension.
But you see, the question, that's the problem. We are allowing our mind to boggle. Now, this can't be their pension as High Court judges, because as High Court judges, they are entitled to a pension of a High Court judge.
That is not.
Part 1 and Part 3.
Yes.
In which case, can you say, I'll withdraw it and I'll pocket this as Union of India or the states? You can't. The states can't say that, well, you are going to get pension as a High Court judge after your retirement. Therefore, I'm going to now pocket this amount. Can a state say that? No, because it's money which they have earned.
No, it's not a question of...
It's because of their service rendered for in the past as judges.
I'm not disagreeing on that question at all.
After all, it is state government money, it is not union money.
No, I think the concept is clear. If I have state has made a contribution along with some other market contribution, whatever it is, it's because it's going to be your pension. If it's not your pension and you want to have your money, will certainly be given back to you.
No, you are entirely right.
Yes.
But pension provided, this money would have a bearing on what pension they will draw as High Court judges.
No.
What pension they will draw as High Court judges is based completely on a different consideration altogether. There's nothing to do with this market-related contribution.
Right, that's why I said prayer is a problem for us. You can't return the entire corpus. Their money will certainly go back to them. There can't be a no on that question.
No, I'm seeking my last injustice, my lord, for two petitions, petition number 2 and 7, my lord. After becoming High Court judge, my lord, they have requested the accountant general to transfer their NPS money, my lord, in the GPF account, my lord. That was transferred, my lord, on 26th of September 2022, my lord. What they have requested, my lord, to seek in license of my lordship, my lord, that my lordship may direct that since that account is blocked, my lord, that money is blocked since 2022, my lord, their amount lying in that GPF account should be transferred to them, my lord, in the salary account with simple interest, my lord. Because that amount had 3 lakhs, my lord, per petition, my lord.
No interest or anything. But whatever is transferred and what is blocked, that money would be made.
Directions will cover it.
Now our directions cover it.
What they are
But now our directions cover it. We have said this money has to be paid over.
What the problem is, Lord, what they are saying in this, Lord.
Interest. No, we are not granting interest.
What they are saying, Lord. Rest of the petitions, Lord, they have got the benefit of the NPS investment, Lord, the NPS contribution. They have not, and they have stopped their.
I think we've drawn a balance. No interest now. Yes.
I'm so glad.
What remains?
Sorry?
What remains is just one small matter. Can I just read out that note and then you're
Yeah, please.
This is just Mr. Dwivedi's matter, my lord.
That is serial number?
That's the third matter in my note.
Third matter in the same.
May make one small request, Lord.
Yeah,
I'm so glad if at all is going to have any implications on the other larger pension issues. So this is
nothing.
necessary.
It's nothing to do with
There's
that.
nothing to do with new pensions. It's not judges who are
Looking
concerned.
at that.
Subject to?
Your Lordship looking at the larger pension issue. Your Lordship may make that observation.
That is already said. We have already said that this is not, we are not dealing with the larger pension issue at all over here. We have clarified that. So that nothing said here will have a bearing on the pension issue. That is very clear. We have said that.
Could that be reiterated that this?
That I've already dictated that before lunch. So that I think you're protected. That's why I deliberately dictated that part separately.
I'm so.
Would your Lordship kindly have page 6 of my first note, Millards?
Page 6 for first note.
You know, these are not, this is a judge, Millards,
Which one?
of the Allahabad High Court, Mr. Jagdish Chandra Gupta. He was page 6.
1262 of 2021.
Yes. That's right, Millards. 1262 of 21.
Yeah.
Would your Lordships kindly see para 19 of my note, Millards?
Yeah.
Well, this has nothing to do with the new pension scheme because this was a judge, even as a district judicial officer, Millards was under the old pension scheme. The third writ petition is being filed by a retired judge of the High Court of Allahabad. It is prayed that issue of writ of mandamus or suitable writ under Article 32 of the Constitution of India, directing the respondents to fix full pension to the petitioner at par with the other retired judges appointed under Article 217(2)(a) and 2(b) the Constitution of India right from the beginning. That's from 27/8/2002. Millards, 3 facts are important, Millards. I'll just read para 20 and then show the act.
The petitioner, who practiced as an advocate for about 14 years and 8 months before he joined the Uttar Pradesh Higher Judicial Service as an additional district and sessions judge on 8/9/77. Thereafter, he was elevated as a permanent judge of the High Court on 22nd March 1996 after serving for 18 years and 6 months. After serving for 6 years, 5 months and 5 days as a High Court judge, he retired on 26/8/2002. The Office of the Accountant General issued payment pension order on 19/7/2018, determining the pension of the petitioner at a lesser rate than those judges who were elevated from the bar. Well, as the operative full years, 6 years. Would your lordships now kindly see the act, lords, which is part of this very compilation?
Yes.
So far as pension is concerned, Section 14, my lords, at page 14 of this compilation. Subject to the provisions of this act, every judge shall, on his retirement, be paid a pension in accordance with the scale and provisions in Part 1 of the first schedule, provided that no such pension shall be payable to a judge unless he has completed not less than 12 years of service for pension, or he has attained the age of 62 years, or his retirement is medically certified to be necessitated by ill health. The emphasis on clause A, my lords, as he has completed not less than 12 years of service for pension. Provided further that if a judge at the time of his appointment is in receipt of a pension other than a disability or wound pension in respect of any previous service in the union or state, the pension payable under this act shall be in lieu of and not in addition to that pension. In this section, judge means a judge who has not held any other pensionable post under the union or a state, and includes a judge who, having held any other pensionable post under the union or state, has elected to receive pension payable under Part 1 of the first schedule. Your lordships will note 14A. Subject to the provisions of this act, a period of 10 years for the purpose, 10 years shall be added and shall be deemed to have been added from 1st April 2004 for the purposes of pension to the service of a judge who is appointed as a judge under subclause B of clause 2 of 217 of the Constitution.
This is from the advocates.
This is for the bar, millards. Now, if your lordship see 15, special provision of pension in respect of judges who are members of service. Every judge who has held any other pensionable post under the union or a state shall, on his retirement, be paid a pension in accordance with the scale and provisions in Part 3 of the first schedule, provided that every judge who was elected to receive pension payable to him either under Part 1 of the first schedule or Part 3 of the first schedule, and the pensionable payable to him shall be calculated accordingly. Your lordships now kindly see Part 3. That's at page 22, my lords. In this case, my lords, there is no doubt he was under pensionable service. He was under the old pension scheme. Part 3, page 22. The provisions of this part shall apply to a judge who has held any pensionable post under the union or state and who has not elected to receive the pension payable under Part 1. The pension payable to such a judge shall be the pension to which he is entitled under the ordinary rules of a service if he had not been appointed a judge, his service as a judge being treated as a service therein for the purpose of calculating pension, and B, a special additional pension of rupees so and so per annum in respect of each year completed service for pension. The proviso is important, my lord. Provided that the pension under clause A and the additional pension under clause B together shall in no case exceed 15 lakh per annum in the case of a Chief Justice and rupees 13,50,000 per annum in the case of any other judge. So at best, my lords, a judge who is not a Chief Justice is entitled to, under Part 3, a pension of rupees 13,15,000 per annum. If your lordship now see page 28, which is the pension order. I just thought it's easier instead of taking your lordship to the paper book. This is the impugned pension order. Your lordship see 5 revised pension millets.
Yes.
Basic pension is fixed at 1,77,035. Your lordship saw that.
1,07,735. Yes.
1,07,735 millets. This figure has been arrived at, millets, using Part 3. What the state has done? What it has done is, it has calculated the pension he would have been entitled to if he was a district judge, plus added to it, B, my lords, a special additional pension of rupees 45,000 per annum in respect of each year of completed service. That 45,000 per
per annum for each year of completed service, my lords, is calculated as 6 years because he has served 6 years, 5 months. So each year of completed service, at best, he gets 6 years because he was in the district judge. Now, I read your lordships 14A, where for judges from the bar, even if they worked for 4 years or 5 years, 10 years is added because of the introduction of 14A, because they get that 10 years additional benefit. So the moment they in fact complete 14 years, they touch the upper limit of 13,50,000. I hope I made myself clear.
For members of the bar.
For members of the bar. Unfortunately, for the district judge, although he has served more than 18-20 years as a district judge, the only benefit that is counted for the district judge is those 6 years which he has actually completed in the High Court. For members of the bar, there is an addition by way of 10 years from their practice. But what is discounted for the district judge is his service as a district judge. I hope your lordship that the discrimination is...
There's no addition made to a district judge.
That 10. So what happens is, a district judge who puts in 6 years, 7 years service also will never make it to the 13,50,000 upper bracket, which is the maximum pension that a High Court judge can receive under Part 3. This argument is flawed. This reading is flawed because, if your lordships kindly see 217 for a minute. Article 217.
So how have they calculated this pension? You said that 1,07,735
is normal pension that you would have been entitled to if you had continued as a district judge. And that special pension is only added for 6 years because he has completed only 6 years. He should have been actually entitled to the full benefit of those 10 years.
Pension is added under that section.
Under that section.
Under Part 3.
That's right. So, if he has completed, if he gets the maximum, that is 13,50,000, which is permitted under Part 3, the learned judge's pension would have been 1,12,500 instead of 1,07,735, because he is not able to get the maximum benefit because completed years of service under Part 3 is only counted.
He doesn't get addition of 10.
Yeah, addition of 10. But that, your lordship, if your lordships kindly see 217 clause 2. Constitutionally, he ought to have served as 10 years minimum a judge for appointment as a High Court judge.
10 years head judicial office.
As a judicial officer. So the Constitution itself presupposes that for a judicial officer to be elevated as a High Court judge, he must have been minimum 10 years service.
Fees per month is what they
take.
Then they deduct his commutation, which is 6,200.
That's right, Mullah.
So 1,01,000.
That's right, Mullah. But he doesn't get full pension of 13,50,000 because...
So it would come to around 12 lakhs?
No, Mullah, he will only get 13,50,000 divided by 12, which is 1,12,500
per month.
Per month. Instead of 1,07,735, full pension they will get 1,12,000, right, sir?
I don't know the exact pension.
Calculation. Because 13,000, 1 lakh.
Okay. Thousand is 1,12,000. Is it per month?
1,12,500 per month. Full maximum. It's a maximum. Under Part 3, 13,50,000 is the upper cap. Their argument is we are unable to reach the upper cap because, like in many of the judges elevated from the bar, might not get the entirety of
So he lost about 5,000 rupees per month.
5,000 rupees. But on commutation family pension, it has ripple effects. It has ripple effects. The point is a principle. The Constitution itself says that to be appointed from the district judiciary to the High Court, you must have put in 10 years minimum service. So if you can count 10 years of service from the 10 years of practice from the bar under in terms of section 14A, because 14A did not come just like that. 14A came as a consequence of Ramakrishna Raju, para 24. 14A was introduced pursuant to your lordship judgment in Ramakrishna Raju, where your lordships, even without a statutory provision, said you cannot put judges who are elevated from the bar at a disadvantage, and your lordships must, and the state must count the 10 years of service, 10 years of practice from the bar towards the fixation of their pensionary benefits.
So what you are saying is that count 10 years for the purpose of computing the special pension in Part 3 that a special additional pension of 45,000 per annum in respect of each completed year of service for pension.
That's right.
You must add the 10 years there because they rank at par.
They rank at par, and that's a constitutional mandate. It's not just a statutory mandate. It's not as if, so far as the lawyers are concerned, because your lordship by interpretation said that 10 years must be counted. This actually, they have served a minimum of 10 years at least. In this case, 18 years as a district judge. So, AC.
I have not applied my mind to this case, but then these are fortuitous circumstances. In every case, you will have a grant of benefit like this, and it becomes an endless calculation.
If my attorney will bear me for a minute. I'm simply saying, Lord, give me the benefit of your lordship judgment in Raju where squarely identical acts have been considered and your lordships have laid down. Just give me that benefit. Kindly have that judgment, my lord. Raju can't do it.
But did Raju say that you must add 10 years for the service judges also?
No, not Raju. Your lordship judgment is Raju, which
That's right. That we place them at par.
your lordship already placed them at par.
Yes.
They take.
There's a break. Apply part 3, that is one which I'm saying, but the other thing I'm saying is that at least because our judicial service, a lawyer can directly be recruited if he has been a lawyer for 7 years. Yes. Para 23, 27 and 30, 31.
30 certainly covers the issue.
Your lordships have already noted that judgment of Raju's law, your lordships 10 years
And we followed Ramkrishnam Raju.
Your lordship followed that, and in 27 the lordship said that the
Question 14A a little bit because 14A was intended to give the benefit to people who are drunk from the bar.
Yes.
And these are people who also put in 10 years of service.
Not only 10 years of service before being recruited in the HJS, we have been a lawyer for 14 years. So 7 years I have to put in order to qualify for being a HJS. So if part 3 is applied, then that benefit of 7 years given, just like in the case of others, which is, and your lordships have given already. So just apply this judgment to me.
Instead of the service of the bar, I would say that it's 217 too, because constitutionally the constitution says that you must be a judge for 10 years. If that benefit is given, they all reach.
So this amount, this particular figure has been fixed of the last pay drawn as a district judge.
That's right.
And not as a high court judge.
That's right.
If you apply 14A, this para 30 straightway applies.
Yes. So the last pay drawn has been taken as a district judge.
That plus the special additional pension of 45,000. That special additional is capped for every year of completed service as a high court judge.
Right.
So for them, what happens is 45 is multiplied only by 6. If 45 is actually multiplied by 10, the moment they also finished 4 or 5 years of service,
Cap the minimum thing at
13,50,000 cap will be attained. At any event below, it can't go beyond 13,50,000.
Yes.
So it's not really, it's a difference of 5,000 rupees. So that person passed away, right?
No, he's alive. He's 84 now.
No, in that earlier case which we
earlier case maybe
No, she was a cancer patient. She was a cancer patient and she was in dire need.
This person is 84.
84.
He retired in 2002.
So
he will get that additional benefit from the date of his retirement. He'll get a substantial amount.
Full pension and
5,000 rupees more.
So if this
additional pension,
I'm not sure about 5,000, but he'll get full pension.
Mr. Attorney, what is to be done here?
I have not really applied my mind to this case, but I thought We are trying to add too many things in a statute, and the statute will be virtually rewritten.
He's put in.
Virtually have to be rewritten like.
No, but he has put in 10 years of service as a judicial officer, because otherwise he can't be appointed as a judge of the High Court.
That's true.
Same thing as in the case of a lawyer, right?
No, but then a lawyer case, you will always came to the rescue of a
10 years
lawyer.
in an advocate.
Coming to the rescue of a member of the bar is in different parameters. Because you have a lesser number of years of service, add a certain quantum so that you get a pension. But to say that in every case of a district judge, to give this benefit of a notional quantum of service.
This para 30. We'll try to persuade you.
Because after all, they have the benefits. I'm sorry.
Para 30.
That's right.
But that will not be subject to the question as to the actual service they would put in.
Now read 14 capital A.
Yeah.
These are the rules, statutory rules.
A period of 10 years shall be added and be deemed to have been added.
Deemed to have been added. And it says, who is appointed as such judge under subclause B of clause 2 of Article 2.
217 2B. Please hand it over. So it is for 217 2B you will get the benefit of the not for any other class.
Not falling within category B, Mr. Dwivedi?
She was not. She was also a member of the district judiciary.
She
was also a member of the district judiciary. That's what happened. There are three sets. She was also a member of the. Look, there were three sets of judgments.
Paragraph 3 says
the Lordship's judgment
appointed as judicial magistrate, and then she was appointed as additional district judge.
2021. The petitioner. Yeah.
They're not dealing with the question of judicial officers. There would be a question of parity, etc. in other services.
No, we are governed by a statute here, separate statute. It's a separate statute only for High Court judges. There's no other. There's a specific statute only for High Court judges. The Act of 1954. That's why this will not.
The losses may suitably clarify.
We have said we are not dealing with a new pension scheme at all. That we are not dealing. The petitioner practiced as an advocate for about 14 years and 8 months before joining the Uttar Pradesh Higher Judicial Service as an additional district and sessions judge on 8 September 1977. Stop. He was elevated as a permanent judge of the High Court of Judicature at Allahabad on 22 March 1996 after serving in the district judiciary for 18 years and 6 months. Stop. He attained the age of superannuation as a judge of the High Court on 26 August 2002. 2002, after serving for 6 years, 5 months and 5 days as a judge of the High Court. Full stop. A pension payment order was issued by the Office of the Accountant General into brackets A and E bracket dash Roman 2 UP, Allahabad, by which his pensionary payments were computed. Next, the grievance of the petitioner is that his pensionary payment has been computed at a rate lower than those judges who are elevated from the bar. Next. context, the pension payment order dated 13 July 2018 contains the following tabulation. Item number 5 to page 28 को in note 1 page 28 को मैंने मार्क कर दिया है. Part 3 full stop. Section 15 of the High Court Judges bracket Salaries and Conditions of Service bracket Complete Act 1954. Footnote देखे Act number 28 of 1954 contains a special provision for the grant of pension to judges who are members of a service. Section 15 is in the following terms. ये page 15 को copy कर लीजिए. 15(1) है. Part full stop. The petitioner elected for pensionary payments. He elected under Part 3, right? Under Part 3 of the first schedule, which is set out below. ये page 22 को Part 3 copy कर लीजिए. In terms of the above, full stop. In terms of clause 2 of Part 3, the petitioner has to be paid A, the pension to which he would be entitled under the rules of service if he was not appointed as a judge of the High Court. Semicolon, and bracket B, a special additional pension of rupees 45,016 per annum in respect of each completed year of service for pension. Section 14A of the Act 28 of 1954 contains provides for the addition of 10 years of service of 10 years with effect from 1 April 2004 for the purpose of pension to the service of a judge who is appointed as a judge of the High Court under Article 217 bracket 2 bracket B. Full stop. Article 217 bracket 2 bracket B. Article 217 bracket 2 bracket A provides for Article 217 bracket 2 provides for the qualifications for appointment of as a judge of the High Court. Full stop. Clause A provides for the appointment of a person who has held judicial office for a period of at least 10 years, while Clause B provides for the appointment of an advocate who has been an advocate of a High Court for at least 10 years. Full stop. Section 14A has provided for an addition of a period of 10 years for the purpose of pension to persons who fall under Article 217 2B. Full stop. The issue is as to whether the petitioner would be entitled to the addition of a similar benefit. Full stop. In this context, it would be necessary to refer to the judgment of this court in the Union of India versus Justice Retired Rahul Garg, no? 2024 INSC 219, where it was held thus. ये page 84 30 copy कर दीजिए वो judgment का. Stop. That apart, comma, it is evident that the petitioner qualified for appointment as a judge of the High Court since he had held judicial office for at least 10 years within the meaning of Article 217(2)(a). Stop. However, the petitioner was also a member of the bar for over 18 years and 6 months, right?
18 years and 8 months. 14 years and 8 months.
14 years and 8 months prior to his appointment as a judge of the High Court. This backdrop, comma, you are of the view that it would be appropriate, particularly having regard to the law which has been enunciated in the above decision, to direct that the pensionary payments due to the petitioner be recomputed after giving him the benefit of an addition of 10 years of service on grounds analogous to those on 10 years of service. However, it is clarified that the maximum pension which is payable to a judge of the High Court of rupees 13,50,000 per annum shall continue to apply to the petitioner. The petitioner retired from service on 26 August 2002. The difference in pension, the difference in pensionary payments payable to the petitioner shall be computed with effect from the date of his retirement within a period of 3 months, and the arrears that are due and payable in terms of the present order shall be paid over within a period of no later than, we say, December, January. 2025.
So will this mean that in every case of a district judge who has less than 10 years of service, they will have the benefit of a 10 years of service?
But you know, look at...
Because this will certainly lead to that logic.
But all of these people have more than 10 years of service as members of the bar.
No, that
all directly appointed district judges have...
17(2)(a) takes care of. Therefore, you are a 10 years service as a district judge, you are eligible to be appointed as a High Court judge. Therefore, to say, go back to a pre-appointment position as a member of the bar. As for unless that
qualification for appointment.
I'm not resisting anything which is fair as far as the High Court judges are concerned. But then this will lead to that logic necessarily. Every judge who has even a 2-year of service and a 3-year of service will say, I'm entitled to count 10 years of service.
But if you give it to the members of the bar, why not to our district judges? They spend their whole life.
So that I'm not resisting.
You know, a lawyer who becomes a judge at 56.
Let's not the attorney be seen as saying that resisting something good.
You know, a lawyer who comes in at 56 gets 10 years addition. Then why not a district judge who becomes a judge for say about, and they don't come at with 2 years of service, because
too many 40
has to be at least 50, they must have at least 58.
These are the fortuitous circumstances in the appointment process. Therefore, how do we, I'm only asking this question, will this mean that invariably for all High Court judges, this rule will apply? Invariably, it will apply then.
But if he has put in 10 years as a member of the bar, we have therefore not said because he put in 10 years as a judicial officer, because he had put in 10 years as a member of the bar.
I'm not debating with the law.
Therefore, he falls within the parity of 14A.
I don't know whether
he didn't come in as a member of the bar.
That would require some legislative amendment to say that. That's why I'm raising this question. Then, unless your lordship say this will not generally apply, then one has to. Then the parliament will have to apply its mind.
Answered in Ramakrishnan Raju clearly.
Ramakrishnan Raju
10 years back in 2014.
Right.
I read this. When a person who occupied the constitutional office of judge High Court retire, there should not be any discrimination with regard to the fixation of their pension, irrespective of the source from where the judges are drawn.
Absolutely.
They must be paid the same pension just as they have been paid same salaries and allowances and perks as certain judges.
Ramakrishna Raju was necessary in order to bridge the gap. Members on the bar did not have the benefit of an adequate pension. Therefore, Lordships made all their observations when traveled all the distance. But to say that in the case, same logic will be applied in the case of every district judge who has even a minimum of 2 to 3 years of service. Please, that's an important question to be somewhere bracketed.
The continuous assertion of the fact that there are two classes of High Court judges.
I tell you what weighed with us. Though he is not drawn from the bar, his eligibility is not, or qualification is not as a member of the bar. But what 14A does is, for people who are drawn from the bar, it allows for an addition of 10 years of service.
For good reasons.
Right.
For good reasons.
Right. Now, a member of the district judiciary who had at least 10 years of service as a member of the bar prior to his appointment as a district judge, which is a laterally appointed, direct recruits act. In that case, what is the justification?
I only ask
the benefit of 14.
I only ask last to ponder over that question because it may have serious implications. Because this,
Not serious.
if it is left unqualified, there could be a problem.
Judges are serving and retired from
If it is left unqualified, there could be an issue.
Assertion that there are two classes.
No.
Every argument is a continuous assertion that there are two classes of High Court judges.
18 years, 6 months and 5, especially plus 6 years as High Court judge. It's already been found.
That issue to be either you ought to clarify that. Otherwise, I think it needs to be dealt with. It left open-ended. I have a problem there.
We'll see how we can best tighten it up. Yes,
I'm sure Lords will do that. Not for without reason, I'm advancing this.
As an aside, Justice Kailasnath Panchu has two distinctions, Manoj, in the history. One, continuous service from 1927 as a magistrate all the way up to the Chief Justice of India. A distinction no other judge, no other Chief Justice of India has had. Two, he's the only Chief Justice of this country, Manoj, who never had a law degree. He was an ICS officer. So I'm saying we have had brilliant judges from the district judiciary who have served this court, Manoj. So this constant assertion that there must be a different class, different conditions must apply to judges who have come from the district judiciary and judges who have come from the bar. I think serious thought will have to go into it. It's not that we've had brilliant judges. I only pointed at Justice Vachu because of the unique distinction he had. He neither had a law degree.
So one should be only ICS judge, or there was
Chief Justice.
As the Chief Judge, there were others as well.
As Chief Justice.
As Chief Justice. As Chief Justice only one. Justice Radha Binod Pal is also.
Justice Vachu is the only Chief Justice without a law degree.
Of Mr. S.V. Raju was a judge in Gujarat High Court. He was an ICS.
Yes,
Justice V.B. Raju. Yes.
V.B. Raju, yes. Who wrote that famous book on V.B. Raju?
It's item 24 will have to be deferred post decision on the NPS scheme because that's I think your lordships will call out that, and I'll give a list of the other connected matters where your lordship will have to first take a call on the pension scheme.
25 now.
I almost covered by lordship round then.
It's under the new pension scheme because I'm sure the Learned Attorney General will have there'll be something to say about this, and this will have impact on the scheme.
We have at least resolved this.
He is also a beneficiary now of this judgment.
25.
That's 25 is the.
He's getting only 15,000 pension, man. Just adjusting that. And yes,
24 is all India judges also.
25 is all India judges, Malaj. 24 is a. Justice Ajit Singh belongs, is a judge who was born under the new pension scheme so far as the district judiciary is concerned, retired as a high court judge.
That may have to be argued.
That's what I'm trying to ask.
My lord, full bench decided in 7.5 and from 1st April 2005.
Let us do something apart from our own judges' pension matters. We must do some other work as well. So we'll take it some other day.
You will depend tomorrow, my lord.
I think so.
Covered by your lordship judgment, my lord.
My lord, with your permission.
Even the amicus curiae is saying that.
I think this should fairly wait the decision.
5 minutes, my lord. I will not take 6 minutes, man.
All right, we'll take it some other day.
Tomorrow, my lord. Then. Some other day is tomorrow.
Too many.
The state of anxiety, my lord. Everybody is.
Too many red flags.
We are all subservient to the constitution.
This is called by Rahul last judgment, man.
That is to be done. That's part of life.
Your permission, my lord.
But this involves a new pension scheme. New pension scheme
Larger issue. So many implications are there, and then there are changes in the pension scheme.
Although it's a high court judge, this has definite impact. That's why I said this must be taken up after the new pension scheme is decided in item 25.
Well, it is, yes. 25 now, no? 25, no?
That's the.
My lord, with your permission, my lord.
Wait, please.
I have filed an MM for a single person who is seeking pensionary benefit.
You can't file. You file your own.
No, your lordship issued notice, and this is a.
How can we deal with an MA in?
It is listed today, my lord.
But you file your own proceeding.
No, your lordship that is listed.
He must file his own proceeding.
In your lordship's last order, your lordship said wherever individual judges have concerns, my lords, it must go back to the committees. Your lordship said.
No, that has been decided, and therefore your lordship's issued notice. Forward.
These MAs will keep coming. IAs and MAs will keep coming, my lords.
All right, yeah, 26.
Well, it's 26 are my applications. I'm the secretary of the Delhi Cricket Association.
I think
This is
Lordship, there's a report.
26.
26 are the IAs. There are 2 IAs which are listed. Which are on behalf, just 1 minute, which are on behalf of the secretary of the Delhi Cricket Association.
Lordship, there's a report by the amicus in this matter, my lord, for this application.
No, but Mr.
Tenure of the earlier amicus.
In any event, I'll just state what.
Report on this. I just want to apprise.
I'll just finish.
I think the contesting respondents are represented by Mr. Ranjit Kumar.
Then we'll just keep it some.
Have it tomorrow.
There's a small issue. It can be kept tomorrow.
We'll take it up tomorrow. We'll take it up.
Sorry.
My lord also list the BCA applications, my lord. It's just for approval. Report has come from the amicus, my lord. The Bihar Cricket Association.
Mention it tomorrow.
Many of the
take it up.
Well, 27, my lord, there is a small issue. If this is, my lord, regarding the coastal road in Bombay.
Yes.
My lord, there was a statement, my lord, which I made that let us have the road built. We will not do anything with regard to, my lord, the outer sides, my lord, etc. My lord, where now, my lord, we have, my lord, someone, my lord, who is doing it free of cost, my lord. What do they call landscaping, etc.
What's the application? Can you show us the copy of the application?
Yes, my lord, kindly have a look at, my lord, 24215.
Once a page there, right?
24215.
Additional?
Look, the road is almost complete. Almost means 96% the coastal road is complete. Only thing which is required is, my lord, on the sides, landscaping, my lord. Sides and the middle, my lord, in the road divider. And we have, my lord, a voluntary agency, my lord, which is doing it.
3315, no?
Yes, but double, I'm sorry, 24215. Two four two five one. My apologies. 24251. Lord, the road is complete to an extent of 96%. Now, Lord, I can.
I'm just briefing.
Median landscaping work and permit the
The
voluntary.
voluntary agency, the Tatas have contacted us that they are ready to do it free, with their logo. That's all. The road is complete.
Who's appearing for the other side?
I'm not aware, but we have served the other side, at the time of filing, quite. But
Some of the respondent, they're supposed to be that side, but they are extending.
And permit them to come carry out the landscaping work.
Need to find a reply to this thing.
Not necessarily this. The IA number 242151 of 2024. The IA has been filed by the Municipal Corporation of Greater Mumbai.
Yes.
Stop. By the order of this court dated 30 September 2022, the certain conditions were imposed, including the following. That is clause 2, right?
Yes.
Para 9 में आए के clause 2 copy कर लीजिए. It has been stated that in pursuance of the above order, a total length of 9.83 kilometers out of the total 10.58 kilometers of the coastal road is completed. Stop. The municipal corporation desires to carry out the work of median MEDIAN landscaping by permitting the agency appointed by it to display its logo and corporate messages at appropriate places in terms of its policy dated 11 October 2024. The permission is accordingly granted, subject to such final orders as may be passed in these proceedings.
Grateful, but I'm told now the lordships are to rise early.
Yes, because you have to go to.
But may mention 22 and 45. This is that NHAI matters.
Yes.
Where we are completely without any protection, and the award is
1,764 crores.
1,700
matters.
Can it be tomorrow?
Can it be day after? That's all I'm requesting. Tomorrow there's some difficulty. Day after it's fine.
Okay, we'll take it up day after first on board. We'll
yes,
yes, first on board.
No difficulty.
27.
28.
22 and 45. They are cognate.
Yes, yeah.
Public.
Is RG Kaur also there today on board?
Yeah, RG Kaur is on board, my lords. Can it be?
I think what we'll do is RG Kaur will take up first on board tomorrow. We'll take it still number 1 on board tomorrow. Because today we have to rise. There's a
yes, but the lordships
for which we have to all go to the Rashtrapati Bhavan. Now, what about the rest of the matters?
Item 28, there's one SLP already here. The other one is the SLP criminal 50109 of 24. If you can have it taken together.
That's Sanjay Kundu matter.
Please, yes, Sanjay Kundu matter. There's the connected diary number 50109 of 24 against judgment. I am a senior advocate who is also subject matter there.
Oh, he's that senior advocate who is there. All right.
That one. So if both can be taken together.
More than item 27, Lord, I'm sorry, item 27 was called out. I was running here and it was impossible to get here in time. Item 27 was we've got something very serious objection to this application. What after filing an application, Lord, in September, based on some previous regime which was there, during the pendency of their own application, they issue an amendment on 11th of October, and based on that amendment, they filed this application saying, give us the permission now as per the new directive. We need to file a reply to that. Under the new directive,
they want to carry out some media.
No, a 30-year, first come, first serve, 15 years coupled with plus 15 years for private concessionaires.
And the earlier one was a temporary thing. It was given for 6 months at a time, not more than 3 years. And this is without open bidding or anything. First come, first serve, 30 years. It is that entire stretch. They filed it. They amend on 11th October. File this on 15th October.
What we will do is,
So please allow us to file a short reply.
What we will do is we'll permit them in principle to carry out landscaping work.
No, the whole thing is to give it to private parties. They are not doing it themselves.
We are
Free of charge.
No, kindly keep it tomorrow, my lord. I'll explain.
1 second.
Yes.
It's landscaping work with the municipal corporation.
It's with advertising.
What we will say is that we are not authorizing them to appoint any particular agency. The legality of that will be decided.
No, it becomes a fair company. 11th, we are today, Lord, on the 5th of November. 11th October, during the pendency of their application based on a policy which has been there for 20 years, they had applied in September to your lordships based on the old policy. During that pendency, 11th October, they issue what is, your lordship may just see that. Please just see that. Now, let me just tell your lordships. Just give me a moment, Lord. Give me a moment. Yes.
I will see your problem that they should not be awarding the contract to a private agency, right?
No,
you can't have an objection to landscaping.
No, our objection is to that development. There's a judgment in our favor. This is an interim order. Your lordships have stayed the judgment, allowed them to.
Well, somebody wants to carry out.
But they're not doing it themselves. Please just see that policy.
But we are not authorizing them to some other agency.
The application is only for that. The application is specifically that please allow us as per our policy of Elam.
Therefore, if you clarify.
Look, what I asked myself this question, that if on 11th October they frame a new policy, 15th October they apply to your lordships, today is the first day of that application comes up without notice to us, without having an opportunity to file a reply. Your lordships are passing an order, and that order is only for that policy, 30 years.
Because the land
cannot
harm environment.
It is harming because it is making that entire thing permanent. There is a judgment in our favor saying this can't be done. They have not taken environment clearances.
Mr. Singh, you also belong to Mumbai, and I've just used the.
I'm only on this, but your lordships never pass orders without giving notice.
Under the sea is there now.
Your lordships never pass orders without giving notice to I'm the successful party. There's a judgment in my favor. Your lordships have not set aside that judgment. Your lordships have allowed them to do some things in the interregnum.
All right, we'll keep it.
So keep it tomorrow.
All right, we'll keep it tomorrow.
Yes,
Then,
yes.
Item
Deeply obliged.
4 is that international commercial arbitration.
Just give us a short note on who you are appointing. Otherwise, what we'll do is we will give you.
It says first come, first serve.
Only
first come, first serve for 30 years.
Mr. Solicitor, you take instructions, you invite tenders for the award of the contract, and then take a decision.
No, the difficulty is tender would mean whoever bids the lowest or highest. Free of cost. They are doing
Free of cost against advertising. The person is going to get money with advertising on that thing. The third party rights are get created.
What is the main litigation about?
The main litigation is...
Just a minute. Yes. It has something to do with legality, validity of the environmental clearance. Right?
Not just the environmental clearance. Also.
Have some patience.
Yes, Manoj. I'm sorry.
High Court said that we are not permitting you to go ahead with this project of making this road.
That's right, the coastal road.
You have to obtain some permission from this authority, that authority. Okay.
That's right. Yes.
By way of some interim orders passed by this court, we permitted them to go ahead with the road.
Only to secure the road?
Just a minute.
Yes.
Please.
Mileage.
Now, a statement is being made that 96% of the road is completed.
That's
correct?
right.
Okay.
Under interim orders of your lordships.
Doesn't matter. It's our order.
Mileage.
It's our order.
Yes, of course.
Now, if that is completed, they want to do some landscaping. If the issue is about who has to do, how it is to be done, whether bids are to be invited or not, it has nothing to do with this litigation. As a public interest petitioner, you can't raise this objection. Who will do it, who will not do it,
your,
on what conditions it will be?
your lordship will hear me,
Does it
and your lordship will pass the orders.
We will.
Because I don't see that the Supreme Court has ever passed orders
Just a minute.
on without allowing the party to be heard.
The order was passed, then you sauntered into the court. Where were you when the matter was called out?
I'm sorry, there's no
You can also
notice.
say that you are not here.
I'm sorry, Lord. I was running and coming to the court, Lord. I got there was a
We
big
can
crowd
pass an ad
outside.
interim order without hearing you. Fair enough, we'll keep it after 4 weeks. That's our ad interim order.
Tomorrow.
Your lordship,
Tomorrow we'll pass
your
it.
lordship said your lordship are keeping it tomorrow.
We'll keep it tomorrow.
Yes.
Let him satisfy our lordships how this harms the environment. His locus is only if there is an environmental damage. And somebody is doing it for free, my lord. Suppose
Yes, all right.
if I
Tomorrow
invite
we'll
data,
see now.
how do I
Mr.
decide?
Solicitor, somebody else now.
Because item 44 is that
Please,
intentional
Lord.
commercial arbitration, which is in realistically speaking, your lordships.
No, I don't think you'll be able to take it up,
my lord. Your lordships. No, not tomorrow, day after. Have it next week, my lords.
We'll keep it after.
Very good.
We won't. I'll reassign the matter because I don't think we'll have
Yes,
time.
my lord,
We'll take a couple of hours at least to complete the matter.
Very great.
Item 31.
With my lord permission, my lord, item 30.
Lordships had heard us on the disability.
Yes.
Of those candidates who
Yes.
took part in the judicial service.
My lords,
We have filed a
yes.
suspicion for
I have also filed, my
So
lord.
lordships can just give us 10 minutes tomorrow, minutes, because pursuant to your lordship's order, 2 persons
All right.
were actually selected.
All right.
That
We'll-
shows minutes what we were.
Fair enough.
Give us 10 minutes.
So those 9 candidates for the judicial.
Because the 41 is connected, my lords, to this matter.
All right.
The
We'll
disability
get
matter.
it.
You may have.
Item number 30.
Matter, the disability matter
Yes,
is to argue it. So we have uploaded the judgment.
That I've seen, my lords. Your lordships have uploaded the other.
Maybe kept tomorrow.
Because item
Vidarbha, because item 4. Maybe kept tomorrow because one of the matters has to be withdrawn and one will take 10 minutes. That Vidarbha part.
Should we record that you are withdrawing it right now?
We'll do it tomorrow when both are called together.
I am here.
You want to engage a senior Mr. Mahesh after for withdrawing the matter?
With my lord permission, my lord.
Yeah, I mean, not neither.
Lords, item 31 on.
You're the other side.
Item 30, my lord.
But I am here, my lords, in item 4.
Item
My lord, I am-
31 is where would your
item 30, my
lordships.
lord. Item 30 is the sanitary pad matter, my lord.
Lords,
Item 30, my
items
lord.
the matter where Professor Danda has made the report.
Who?
Professor Danda?
Danda.
Yes.
That Rajiv Raturi, that
Yes.
disability report.
report.
Yeah, we have to hear that.
And the written.
My lord, item 30 is also very important. my lord.
Vikramjit has also filed for the government. Yeah, we've seen those written submissions.
My lord, item 30, my lord, is the sanitary
That
pad
will pick up
matter.
tomorrow because
My
it has to
lord,
be.
may I just-
Last time, Dr. Amita from Nalsar, right? She was here on the screen last time.
Yes, sir. She's
We'd also like to hear Dr. Danda for 10 minutes tomorrow.
Lords, item 31 as well, would your lordships have it tomorrow, my lords? That's the arbitration petition wherein there is a divergence of views between high courts when
There's no divergence of view. It's a Colombian arbitration clause.
Oh, that provides for the
Bogota. That's correct.
That's matter.
That's right. I mean, it should be dismissed. It's not maintainable also.
And there is
The way here.
and there is
I agree.
conflicting.
Let's please have it tomorrow and please send it
Lords,
to me.
one way or the other, because there is a specific exclusive jurisdiction clause.
It's the matter, but we'll give you a hearing tomorrow.
I have no difficulty.
I saw it in the morning.
Lords, the reason being, my lords, what various high courts have held that the exclusive jurisdiction clause decides the seat of arbitration.
Let's part
and
one
not
has
the
to apply
place-
in the
not the
first place.
placement.
How does that come?
Just wait till Thursday. We are pronouncing a judgment on this. Either of the
I think-
side will be governed by it.
Then would your lordships have it next week or next Tuesday?
Whenever, as your
Item 5.
Grateful.